All right. It is a true pleasure to welcome you all to this event marking the 20th anniversary of the Children's Online Privacy Protection Act. For those of you who don't know me, I'm Alexandra Givens. I'm the Executive Director of Georgetown's Institute for Technology, Law, and Policy. For those of you who aren't familiar with the Institute, we launched it 2 years ago as a way of bringing together all the phenomenal things happening in technology here at Georgetown. We now offer over 50 classes to students in the technology, law, and policy space, drawing on some of the excellent faculty that you'll see speaking today. Our students are studying topics ranging from the governance of AI to the use of technology in the criminal justice system. And the Institute, our Privacy Center, our clinics and centers are doing applied policy and legal work out in the field as well. It's a phenomenal team, and I'm really humbled to be part of it. I want to start off by thanking our co-hosts for this event, the Future of Privacy Forum, the Center for Democracy and Technology, Consumers Union, and Common Sense Media. When we began planning this 20th anniversary event, it was really important for us to join forces with others that are leading some of the work in this field. Like our speakers, our co-hosts are true leaders on this issue, and it's been a pleasure to work with them. And we have a special thank you to the Future of Privacy Forum for providing the refreshments and the meals that are here today. COPPA has a special meaning for us here at Georgetown. Our Institute for Public Representation's Communications Clinic played an active role in the work that led to enactment of the law in the 1990s under the leadership of Angela Campbell, who you'll hear from on our third panel today, and in partnership with many of the folks who are here in the room. Over the past 20 years, law students in our clinic have worked to protect children's online privacy. They filed 13 requests asking the FTC to investigate alleged COPPA violations. They filed extensive comments in the COPPA update rulemaking, and they submitted comments on all of the safe harbor proposals to date. Our three moderators today, all from Georgetown, each have direct experience with COPPA too. Dean Paul Ohm, who will moderate our first panel, was a senior policy advisor at the FTC at the time of the 2012 amendments to the COPPA rule. Laura Moy, who is now executive director of our Center on Privacy and Technology, led the IPR clinic in 2016 when it filed a complaint over influencer marketing on YouTube. And Professor David Vladeck, who I'm sure is known to many of you, of course, ran the Bureau of Consumer Protection from 2009 until 2012. We're thrilled by the caliber and variety of voices you'll hear from today. They may not all agree with each other all the time, but they agree that these issues are really important, and we're thrilled to have them here. We're also very grateful to be joined today by FTC Commissioner Rebecca Kelly Slaughter. Commissioner Slaughter was sworn into the FTC in May of this year. Prior to joining the commission, she served as chief counsel to Senator Chuck Schumer, working on a wide variety of issues, from intellectual property to communications policy, consumer protection, and privacy. I had the pleasure of working with Rebecca for a number of years on the Senate Judiciary Committee, so it's particularly meaningful to me to get to introduce her today. Already in her short time on the commission, she's carving out an important role at the intersection of privacy and security, including a lot of talk about connected devices and in the Internet of Things. She's a nuanced and careful thinker on these issues, and so I'm thrilled that she'll share some of her thoughts with us as we start today. I'll invite you now to the stage for opening remarks. Please join me in welcoming Commissioner Slaughter.
Thanks, and Alex beat me to the punch of bragging about how I got to work with her in the Senate. I was really the lucky one there. It was an incredible privilege, and it is also an incredible privilege to be here today. So I want to thank the Institute for Technology, Law, and Policy for hosting today's important event, COPPA at 20. It really is an honor to be here with you to mark this milestone in the protection of children's online privacy, and to use this opportunity to reflect on where we have been successful in our efforts and where we could refine our approach. 20 years ago, Congress passed the Children's Online Privacy Protection Act. The act directed the FTC to develop regulations requiring operators of commercial websites and online services directed to children under 13 to give parents tools to control what information is collected about those children. Following Congress's directive, in 2000, the FTC promulgated the COPPA rule, which set forth regulations requiring operators to notify parents of their information practices, obtain verifiable parental consent, collect the least amount of data possible, and maintain reasonable procedures to protect the confidentiality, security, and integrity of children's personal information. The Act provided the FTC with civil penalty authority to encourage compliance with the COPPA rule. Since the enactment of the COPPA rule, the FTC has brought 28 cases to enforce it. Those cases have yielded millions of dollars in civil penalties and have put strong provisions in place to require violating companies to change how they collect and protect kids' personal information. Two recent examples are actions against the seller of internet-connected toys and against a web-based talent search firm charged with violating COPPA. As we know, however, the world has changed quite a bit in 20 years. The popular portable devices for kids in 1998 were Game Boys and CD players. Pokemon was simply an inscrutable trading card game, which it still is today, I know, because my 6-year-old really likes it. It is also today one of the most downloaded mobile games, relying heavily on augmented reality and geolocation technology. And like all of us, kids are spending more and more time online. According to Common Sense Media, average mobile media time for kids has tripled from 2013 to 2017, increasing from 15 minutes to 45 minutes a day. The FTC has worked to keep pace by adapting COPPA to address innovations that affect children's privacy, social networking, online access via smartphone, and the availability of geolocation information, to name just a few. After hosting a national workshop and considering public comments, we announced changes to the COPPA rule in 2013 that expanded the types of covered information to include photos, videos, or audio files that contain a child's image or voice. Just last year, the FTC issued an enforcement policy statement that addressed the practice of collecting audio files that contain a child's voice for immediate conversion into text in response to inquiries from the marketplace as this practice became more common. I know the FTC will continue to do everything in its power to respond to developments in technology and ensure that the protections afforded by COPPA are as effective as possible. But today, we are also at a pivotal moment when it comes to privacy. There is widespread acknowledgement that all of our citizens, not just our youngest, are in need of better data security and privacy protections. There is a long overdue push for the federal government to step in and provide those protections. COPPA can serve as a valuable model for how to develop substantive and flexible regulation supported by meaningful enforcement. The COPPA Act empowered the FTC with specific rulemaking authority coupled by civil penalty authority. And I think most people who are not steeped in the weeds of the FTC don't appreciate that, unlike many other independent agencies, the FTC generally doesn't have notice and comment rulemaking authority backed up by civil penalty authority. So COPPA is a unique carve-out there that gave us real tools. The FTC was then able to craft a rule that gave clear direction to industry on the protections they needed to provide, guidance on how to do it, and the flexibility to achieve those protections in a variety of ways. Technology changed, and so did the rule. We hosted conferences for fresher input, sought comment, and amended the rule. When new types of risks and questions have arisen, the FTC has updated its compliance guidance or its enforcement policies. In thinking of COPPA as a model, it is also important to remember that COPPA faced significant opposition. Even the 2013 amendments to COPPA were fiercely opposed. Some of the predictions from the opposition included that the new rules would prevent websites and developers from developing child-friendly services, or as another critic put it, kids will get fewer and lamer apps. To the dismay of parents everywhere trying to get their kids to unplug, myself included, those fears have not been realized. As we grapple with questions of how to balance increased privacy protections without chilling innovation, COPPA is instructive that it is possible to establish a baseline of security and privacy protection without impeding the pace or ingenuity of our innovators. As much as COPPA has been a success and can serve as a model for effective privacy regulation, we also know that the risk that kids and parents face online grow ever more alarming. This 20th anniversary provides an opportunity to also take a critical look at COPPA with an eye toward what more can and should be done to protect children's privacy. Can the FTC better keep pace with changing technology in its COPPA enforcement? Does the explosion of home IoT devices pose new risks for kids, and can COPPA effectively address those risks? Does the framework of COPPA fairly apportion responsibility among the many market participants involved in delivering online content to kids? And has COPPA's safe harbor meaningfully increased compliance? Beyond the specific questions of the effectiveness of our enforcement are some larger questions about children's privacy that are necessarily a part of any serious reflection on COPPA. Right now, my kids are young. I still have many years before they pass outside the COPPA safety zone of 13. But parenthood so far has been consistent in its relentless speed. I'm at the next stage before I've settled in to enjoy my momentary mastery, or lack thereof, of the current one. I know that the teen years are headed my way with the same alacrity, and from my own personal experience, I don't recall those years being a high point for good decisions, sound judgment, and circumspection. A critical question worth revisiting is whether we're offering enough protection for our teenagers. GDPR expands the age range for covered children's information and now requires parental consent for collection of data from kids up to age 16. Should we do the same? Or are there more effective protections for teens that we should consider instead of parental consent? Finally, it is important to think critically about better protections. It is important and impossible to think critically about better protections for kids online without addressing the rising levels of technology addiction. Should informed parental consent require operators to disclose information about the risks to children of overuse? And do we know what overuse actually is? We routinely think about the practical implications of our legislation and our rulemaking, but we also have an imperative to consider the ethical implications and the social cost-benefit analysis. Taking this anniversary is a time to evaluate the effectiveness and the limits of COPPA and ask ourselves whether and how we might reach beyond those limits is important and timely work. I'm excited to engage in this dialogue with expert input from the excellent panelists this afternoon, and I look forward to continuing the conversation. Thank you so much for having me.
All right, I'm going to go ahead and call the first panel.
Hi, I'm sorry. I don't know.
That's all right. How you doing? Is Morgan here?
He is. He's kind of sorry about that.
More
Tight
space, actually. We do have more space.
I'll spread out a little bit.
How you doing? So thank you to Commissioner Slaughter for those wise words and really nice job setting the table. And thank you to you all for coming to take part in this conversation. It warms the privacy nerd in my heart that we can fill a room on a topic like COPPA at 20. And I hope that we can kind of kick the day off following the commissioner with some important level setting. I will start with an announcement that Lisa Guernsey, who is on your agenda, wasn't able to attend. She had a last minute crisis that she had to deal with. And so because of that, you've got fewer of us and probably the opportunity for us to be a little more voluble, and that's never been a problem for me. I will say that Lisa did bring to this panel kind of a deep and rich understanding of the research on what technology is doing to our children. And so I'm going to invite those of you in the audience who kind of have a lot of research and then in that part of the debate that we're having to kind of raise your hand and contribute the pieces that we might be missing. Our panelists know a lot about that as well, but I wanted to make sure that I made that invitation. So let me briefly do what I never do and highlight some of the kind of impressive biographies of the people who are up here sitting next to me. I usually don't do this because your programs do the hard work, but our program does not. So let me just fill in some. Katharina Kopp is at the Center for Digital Democracy. She was really kind of on the front lines of the creation of COPPA and has been involved with it ever since. And has spent a lot of time both kind of on the NGO side and also in the private sector thinking about these incredibly important and hard issues. Sarah Kloek, am I?
Cluck, like a chicken.
Cloak like a chicken, is at the Software and Information Industry Association. but has really kind of seen COPPA from just about every angle you can see it. At the ACT, the App Association, and also at the Department of Education. And she is one of the kind of few people in the world who really understands the overlap of the Venn diagram between COPPA and FERPA. And so I might force her to talk a little bit about that before we're done. And then last but not least is Morgan Reed, who is at the organization that Sarah once was, the App Association. Morgan is the president of that organization with more than 5,000 members, and obviously has a kind of deep insight into what a law like COPPA means for innovators and innovation. Morgan also has probably the number one thing you could have on your biography to endear yourself to me, which is he says he's a recovering software engineer. You're never a recovering software engineer. You're a software engineer.
Till the day you die.
And so hopefully you'll indulge us as we geek out. Let me just tell you a little bit about my biography, partly because I intend to be an annoying moderator who says a lot as opposed to a passive one. I'm a professor here. I'm a faculty director of the institute that's holding this event. I specialize in information privacy. I am a software engineer, and I teach Python programming for lawyers. And among other things in my checkered past, I spent 1 year at the Federal Trade Commission as a senior policy advisor, and that was the year we wrote the COPPA rule. And so I was in the 2012 version of the COPPA rule. And so I was in lots of rooms with some of the people here thinking about kind of what innovation had done to this venerable old law. So let's start there with the venerable law. And Catherine, I think you were most on the front lines when this law was first created. The charge for this panel, and it's going to be hard for us to honor it, is we're going to focus on the technology. We're going to ask questions about the tracking that happens to kids, parental consent, all from a technological viewscape, hoping to set the table for our later conversations about the law itself and the enforcement of the law. I'm sure we'll stray a little bit into giving some opinions about the law as well, but let's try and stick to the technology. So can you describe, and take as much time as you need, kind of the technological landscape at the time this law was created, maybe hit some of the highlights of what's changed since then, especially around the time we got the new rule, and then what's it like today?
Sure. Thank you. Thanks for having me, and thanks for the this event here today. I appreciate the framing in terms of technology, but if you know Center for Digital Democracy and my colleagues Jeff Tester and Catherine Montgomery, who were instrumental in the passage of this law, we also always look at the business landscape and the business model. So I'm going to sort of weave this into this conversation here today, because I think that's really the driver of the technology. So at the time in the early 90s, advertising on the internet, nobody really thought about that would be sort of a dominant feature of the internet, and really advertising to children was on television, which was, somewhat regulated. And the Center for Media Education, which is the sort of the predecessor for the Center for Digital Democracy at the time, was looking at the digital marketplace for children. We attended industry conferences, and we did a lot of monitoring of the practices on the web. And one of the companies, for example, KidsCom, that we looked at, which was then the case that was brought to the FTC, was one of the basis of the report that we issued in March of 1996, the Web of Deception. And I can just sort of summarize a little bit what we showed in there. And one of the most important things, I think, as it is today, we highlighted that the driving business model that drives the technology was the one-to-one marketing that was really the goal of companies as it is today, to collect as much information about the consumer, about the child, to then have a personalized, micro-targeted message to optimize the outcome, either purchasing or influencing the child or the user, the consumer, and really to create sort of an irresistible message based on preferences and behavior of the online user. But when we looked at some of for example, the KidsCom website and other websites, at the time, the predominant way to collect data was through a direct solicitation of children. So they had surveys and games and merchandise. There was sort of incentives to have the child fill out a form, often to actually ask very sensitive questions about the family, income, status, like something like that. And so there was sort of a more direct solicitation. And for example, for the movie Batman, there was a website that sort of asked as a good citizen of Gotham, you need to fill out the survey to participate in this website. So in a different study, we found that about 90% of the most popular children's websites then attempted to gather information. 40% had some kind of incentive, again, through merchandise or games or gifts or tokens you could collect. And only 40% did it through cookies. So the passive collection was not as dominant then at the time. But we did feel that that it was important for the future of this medium for children to limit data collection and to develop rules of the road and really. It should be, I think maybe also we should remember that at the time there was a discussion to have general privacy legislation. It wasn't just about children at the time. So in the end, CME was promoting the age limit of 16, but we ended up with 13. But it was really important to have the flexibility around the technology baked into the legislation so that we could adapt it as it changed. And then, so one of the comments at the time from Senator Markey was also that really, regardless of technology, regardless of the channel, whether it was, the phone, TV, satellite, web, that individuals had a certain privacy rights and expectations to privacy, and that should be safeguarded. So we were happy to have the ability to adapt as the technology changed. And then, as you mentioned, as we know, there was an updated rulemaking, and that was, again, reflecting now the change in technology. So we had a huge increase in use of mobile phones. We had a huge increase in now popular social media. Third-party tracking was now, much more dominant. And so all of this was incorporated in the rulemaking. And so now it covers ad networks. And if ad networks have actual knowledge of these data practices, then they also have to obtain the consent from the parents. Definition of personally identified information was updated to have persistent identifiers, geolocation, and all forms of passive collection. So now we see much more the emphasis of the passive collection of data that as the technology had changed in that way. And then, as it was already mentioned, photos, audio, and was also included. And, any sort of behavioral data collection was supposed to get limited. And then, since then, I had here a little list here, and I don't even know where to start.
Yeah, why don't we pause on
Yes,
that, and then
sure.
we'll bring us to,
Yeah.
so in your timeline, which was extremely helpful, we understood that, and I think this was my lived reality as well, although I wasn't even a lawyer for this entire span, but from 98 to 2012, some kind of profound evolution in technology generally, in the way we interact with technology, and then in particular how it affected children, right? No social media when the law was first enacted, no smartphones when the law was first enacted. Those two things alone are the kind of twin pillars. And so this is kind of a jump ball to both Sarah and Morgan. You were both kind of active in either the development of or working with the developers in 2012. Right. And so does this kind of resonate with what you're hearing, that a law written in 98 was written under very, very different conditions than 2012? Let's make this like a suspenseful TV show and hold off talking about what's happened over the last 6 years for the next question. So what do you think about the kind of evolution for those 14, 15 years from the enactment of the rule to the time of the law to the time we got the new rule?
Well, in 1998, I was 15 years old.
Yeah. So tell us about it. Were you?
And I lived in rural Minnesota and accessed the internet in my parents' bedroom on the one desktop device that we had in the entire house. It was top of the line, my dad would like to say. He was and still is a technology junkie, but the way that I accessed technology as a teenager, my parents always knew what was going on because I was in the room with them, or using a device that was in their bedroom. And I think we know that things have changed a lot since then. Kids now have mobile devices from early ages, and we all have multiple devices where we're accessing all the time. I know I have my phone in my pocket. I see at least 4 4 other devices, 5 if you, yeah, 5 other devices up here. So there's a lot more connectivity happening. And I think I'll let Morgan talk a little bit more about sort of the evolution of
Yeah,
apps specifically.
I think Sarah brings up some great points, but I also want to caution us from this idea that parents knew exactly what was going on, because I'm old. I'm 50, and my parents had no idea what was going on, and we didn't have social media. I learned to program, my first program I ever wrote was with my father, was a computer science professor, on punch cards. That's how old I am. And I will tell you, as a child of the 80s, of the 70s and 80s, no one had any clue what we were doing. We left the house in the morning, we came home at night, and nobody had any idea of the social drama that we enacted in our, she grew up in, Minnesota, I grew up in Alaska. We even had drama up there. So I want to be very clear before we often have this, and all of us in this community of the child privacy community have a tendency to, once we see something, think it's happening more often. I'll remind all of us that all of the horrible things that we're afraid of are less prevalent today than they used to be. Stranger kidnappings are down. Many of the characteristics that you think of, the few areas where it's increased is actually a good thing because it's being reported more often. So there are actually some good that has come out of it, and parents are more aware of looking over their child's shoulder to see what they're up to. I grew up in the era of War Games, the movie War Games, where, it was a sport to make fun of parents, and as the child, changed his grades online, if it's Ferris Bueller Day Off and others. So as we talk about where we are, I think we shouldn't treat the parents as idiots in this equation. And we should look at how are the apps and the ecosystem, how are we doing a better job to bring the parent along rather than saying, oh, well, the parent. Because I'll remind you, in the 70s, parents had no idea. Parents are more aware now. But I think what is a little different with the app ecosystem is the ripple effect. So in the technology of my era, if I said something to Leslie Lumberg, and then Lance Lumberg, real people, and Lori Lumberg heard about it, that's about as far as it went. Maybe it went to Jon Snow, who lived about a mile away, but that was the entire impact zone of whatever bad thing or good thing happened. The drama had a limit. I think the area that gets very interesting in the era of social media and connected devices is, where is the limit of that ripple effect of what the child is posting and what people know? So as far as what's changed, the blunt reality is, as Sarah accurately pointed out, she said everybody here has got a smartphone in front of them. The average person in America is never more than 3 feet away from their device. We have 350 million active devices, and we only have 315 million people in this country. In less than the adoption of mobile technology is the fastest adopted technology in the history of mankind. It is faster than fire, it is faster than the microwave, it is faster than any other technology you can think of. We now have 7 billion people with access to basically the world's information at their fingertips instantaneously. There are people in Bangladesh who have dirt floors, no power, but they have access to the exact same information you do via the internet. So let's not forget that this is, to Katarina's point and to Paul's point, there is no question that this has had a profound societal impact. I'd argue it's generally been a very good thing. But to narrow it into the COPPA question that we're all here to discuss, I'll come back to, I thought it was funny. I actually am pretty sure that Becca's quote, Commissioner Slaughter's quote about fewer and lamer, that was actually me in my 2011 testimony before the Senate at the time. And I stick by that quote in the sense that we need to always be thinking about, are we using COPPA in a way, or is COPPA being used in a way that actually prevents good products from reaching children, that helps developers that want to be conscious about privacy from engaging with parents? And the work that Sarah's done and CDD and others, I think that those are the elements that we want to do. So in short, on the technological hops, yes, profound impact. Mobile apps are now in everybody's hand. They're in front of every child. They are global. They are impactful. The next question that we have to ask is, how are we making that the right environment for parents and kids?
So you mentioned Jon Snow. I had a question about the boat ride in Daenerys Targaryen, but I'm going to delay that one for later. There was a little tension, I think, inherent in your answer, and so I want to follow up to try and tease it out and see if others want to jump in. I mean, I think you're trying to acknowledge the complexity of both sides of this debate, and on the one hand, you started by saying the things we worried most about are less prevalent today than at the time, and at the same time, and that argument could support, we didn't need a COPPA back then, we certainly don't need one now. That could be one.
I want to be clear. My
Yeah.
testimony, even back in 2011, I reread it. It was shockingly supportive of
Yeah,
COPPA.
okay.
So, yeah, I
But
want to
then-
be clear. I don't want to be on the record saying. I
Then maybe
didn't
there's
support
less
it.
tension than I detected, because
No,
then on the other
no, I
hand,
think
you
that's
said,
fair.
but a lot has changed and a lot is more complex,
right.
and you called this the ripple effect. I would go back to the first statement. If the things you are worried about today are things like cyber stalking or, manipulation of children, it's hard to argue that things were better today than they were in the 1980s, right? And I too was a child of the 80s.
Wait a minute.
I watched a lot of
Stalking?
sugary cereal on TV. Commercials, but at the same time, I knew that no one was watching me watch the commercials on TV, right? That has been a fundamental change, and it's the change COPPA was meant to
Well, I think
address.
Paul raises a really important question that everybody in this room knows, and it's the inherent tension in the COPPA discussion. And Katerina brought it up, and Sarah hinted at it, which is COPPA about children's privacy, or is COPPA about advertising? And that is at the core of a lot of this discussion. And so, or is it both? And where does it sit in that environment? So I think, Paul, your tease out is that. You mentioned the sugary cereals.
Yeah.
Katerina noted that was one of the things that they were trying to address when they first moved forward on it. So, yeah, I think that's the inherent tension in COPPA. Which is it? Or, as Katerina said, it's both?
It's both, yeah.
There you
You
go.
cannot separate privacy and data from advertising. So to me, it's by, we were interested in preserving some kind of, space where there's some rules of the road around advertising that's connected to privacy. And so, yeah, the two are intertwined.
So let's bring us forward to 2018, right? Because again, I was at the commission at the time we were dealing with some of the fundamental changes that had occurred. I think I'll state this instead of as a question. Maybe I'll start with Sarah. Just here's a claim. The claim is that the changes that we've faced since 2012 are less substantial, less significant than what we addressed when we rewrote the rule. And again, this is a claim that I think you can argue both sides of, so I want to hear your response to that. So what are, and that makes sense, right? We're talking about a smaller period of time, although at the same time, innovation seems to be getting faster and faster every year. What are the technologies today that I think kind of profoundly impact children, parental control, frame these issues however you want, that maybe aren't getting, the coverage in COPPA that they should be? Are there gaps? Are there things we should be thinking about?
Well, I think the things that have changed dramatically since 2012 have been both business practices and consumer expectations, whereas the technological change between 1998 and 2012 the changes there was probably technology. So I think we're looking at a world now where we have GDPR, we have businesses that, what was the 2012 FTC report, mobile app, I wrote it down. Mobile privacy disclosures, kid app disclosures are disappointing or something like that.
App pointing.
Yeah.
Who wrote that, Paul?
I did not. No, that was not me.
It's one of the few reports names that sticks in my head, so it worked. But I think we're looking at better privacy disclosures. They're not 100%. All of them are amazing, but we're seeing sort of changes in the way that companies are communicating with consumers, and consumers are communicating their expectations to companies. You'll see people leaving businesses because of their practices or choosing businesses because of their practices, which I think is, I remember attending a developer conference in 2011 and had a table set up to talk about privacy, and no one wanted to come talk to me. It was such a lonely conference. But now today I was at a conference in June, and there was a panel on privacy, and the room was full, and there was overflow, and people couldn't get in. So I think there is an interest in it, and both businesses and consumers are sort of adapting to that.
Yeah. Go ahead,
So,
Morgan.
Paul, I want to note Sarah's excellent point about expectations. And I think that's at the core of both what's been good, but also one of the problems, because I think COPPA as a mechanism that's based on collection and the arduous verifiable parental consent mechanisms that exist failed to meet the expectations of parents in all cases. I think there are some companies out there that have been very privacy forward, that have done a very good job at just-in-time notification and engagement in stages that's far better to meet the expectation of a parent. What we learned through user testing, and I think that's why what Sarah said is so profound. What we learned through user testing and focus groups are, if you add a lot of friction, the parent is going to lie or move beyond it or hand it over the thing, or worse still, and this is why I stand by my comment to Becca about worse and lamer apps, or fewer and lamer apps. It's not that there's going to be fewer apps overall. It's going to be fewer and lamer apps that are directed at children in a good, healthy, safe way without, to Katharina's point, without advertising and have other mechanisms. So we have to be very careful with expectations that we actually provide the information to the parent in a way that's helpful, that guides them. Apple gets first credit for coming to the table with a lot of just-in-time notification and the way that they did a lot of parent engagement. Google has since copied it, so it's something that showed that there was a pathway for good parent engagement. But to Sarah's point, if the model is this consent mechanism model, then there's an enormous amount of business incentive to essentially pass through the hurdle of consent and then Katie bar the door, do whatever I can on the other side. And I think that's not helpful for parents. And what we learned, and I think Sarah would echo, is we learned for developers that were trying to do the right thing, it's very hard to be in an environment where if I want to monetize, I don't want to monetize through advertising. I've got to compete with people who are just trying to figure out how to get through that hurdle as fast as possible and then monetize like crazy through the eyeballs and the advertising. So I always had a little bit of tension that exists between a consent model that doesn't necessarily meet parents' expectations. And I think that's the thing that we should all be thinking about as we move to the next generation of COPPA. How do you do just in time? How do you lower the friction? How do you make the safe harbors and the verifiable consent mechanisms more impactful for parents, not just for advertisers?
And let me just throw a few examples out there that we haven't really invoked. I want to keep this as concrete as possible. So Internet of Things, gadgets, the commissioner spoke of those. We have a lot more streaming video today, although we certainly had a lot in 2012. Gaming platforms are really starting to grow. Streaming gaming, right? Put those two together. Apps continue to grow, although they were a pretty significant force in 2012. Social media. Third-party ad tech, where you keep returning us to, and even innovations in smartphone around sensors, and of course there's a substrate of artificial intelligence below all of this, right? So of those, is there one on the list or two on the list that you think really kind of are showing the kind of frayed edges of COPPA that COPPA isn't so good about dealing with, or?
Yeah, so for me, also, again, the context is there's been a huge growth in the advertising market for children.
Yeah.
So there is a 25% growth year over year. So there's a lot of money in this space, right? So the incentives are going to obtain consent from parents and then be able to do what you want to do with this data. So for example, streaming video, right? So it's easier to get consent this way, and then anything goes. And so this is, I think, where we reach the limitations of COPPA. Once you have obtained a consent, we really need to start thinking about what are the limits around the use of the data. And so I think I just want to raise artificial intelligence, machine learning, big data. I don't know which term you want to use.
I don't want to use that one, but you can use the other
But
two.
any of those terms really raise issues that I think COPPA hasn't been grappling with, right? So it raises the issues of profiling, especially around race, discrimination, and really anything classifying predictive analytics really let us think about also the question of equity, right? So who are the beneficiaries in a larger context? Because, COPPA forces us to really think about the parent and the child and sort of this, what I like the privacy self-management framework, which I think is sort of has its limitations, but we really need to think about more on a societal, on a group level, who are the winners and losers in this. And so, for example, we work on a project around junk food marketing, and, there is the evidence that for the obesity crisis, the kind of marketing that we're seeing are disproportionately affecting families and children of color. And so those issues, we need to start thinking through when we talk about COPPA Plus.
So I've been a bad moderator. I should have told you at the outset that I'm going to leave 15 to 20 minutes for questions from you, and I really would love to kind of bring you into this. I have a dozen more questions that I want to ask. I'll get through as many as I can. So Morgan, we've now teed this up several times, and I think I've heard from you implicitly and somewhat explicitly the net effect of, and let's not just say COPPA, but all sorts of kind of regulatory pressures that people like your members feel means there's less innovation today for children than there could be. And Commissioner Slaughter started us by saying, we're not here to stop innovation. We think we could have innovation and parental notice and control and a modicum of children's privacy. So let me push back on that in a mild way and then in a harder way, and hear your responses. The mild response is, it seems crazy in 2018 to have a sentence that begins, that's mild, by the way, it seems crazy. We don't have enough innovation in X, right? I mean, stop the innovation bus. I want to get off it. There's so much crazy innovation, especially as a parent. I think it's de rigueur today to mention how old your kids are, a parent of 13-year-old twins, right? To kind of watch the innovation that has come into their life in the last 3, 4, 5 years. And I guess maybe the argument is, yeah, but imagine how great it would be if we were freed from the shackles of some of these regulations. I don't want to imagine that. That's a terrifying thing. The second, I guess I claimed it was stronger, but I think it's the same argument, is why is it such a bad thing to have less innovation for a cohort of children that the law in so many ways recognizes as special, vulnerable, in need of assistance, especially with the kind of burdens on parents today? Isn't it a wonderful thing to say, my God, it'd be great if we could just send Timmy out into the street with a stick and a hoop. There would be so much less to worry about as a parent. Why do we have to, as a starting point in our debates, anything that impedes maximal innovation is a negative thing that we ought to fear, especially with children? Isn't a little less innovation wonderful, right?
No. And here's why. It's funny, Katarina mentioned sugary snacks, or what do you call it, junk food snacks. The problem that you've created with the mechanisms of COPPA is the people who are making the applications that are the healthiest, quotes around that, are the ones who face the greatest hurdle. And parents in particular, and kids in particular, want as little friction as possible. And so what ends up happening is the apps that win are the sugary snacks. The apps that don't win are the ones that are thoughtful and healthy and good. So if you said, well, the choice is less innovation and they're playing with a hoop, maybe we can have that conversation. But what I see, and Sarah was a big part of this, and several other people in the room were, building a network of more than 500 companies that built apps that were privacy thoughtful, COPPA thoughtful on day one, and watching them struggle to break through the sugary snack of the app that didn't behave in that way because it was, quote, general audience. I saw more of the people who did the cool Montessori app, or the app that mixed gamification with learning states, or any of those. They found the barrier of COPPA, meaning the need to collect some information in order to provide a better user experience. They were trying to do the right thing, and by trying to meet the restrictions under COPPA, they found that the market was flooded by less healthy, I hate that term, apps. So your dichotomy is a false one, because the equation is not hoop versus innovation. It's hoop, innovation, sugary snack.
Yeah, but I think there's a fourth category you're missing, which is sugary snack and then mainline sugar directly to the vein, which is...
Okay, same thing.
So you may... It's hard to prove what you don't have, but you may not have apps that are all about, profiling children, marketing children, following children. They may have no place whatsoever in the ecosystem because the law makes it really, really, really... So it's hard to be healthy. I totally will grant that. But it's even harder to be a heroin dealer, right? And maybe that's a good thing.
Wow,
I don't
I'm not
know.
gonna...
So are you pro-heroin for children or against heroin for children?
Yeah,
I'm kidding.
I think we went a little too far. You jumped over the cliff.
I've been known to do that, but I landed on the other side.
But I want to let Sarah have a chance to talk here about that.
So I think one of the important thing, we can talk as much as we want about innovation, but making sure kids get access to information so they can learn things that they otherwise wouldn't have access to is important. The internet, when I was growing up, provided an avenue for me to learn about things that I would never get to because we didn't travel when I was growing up, that I could, kids today can go and take a virtual tour of the Louvre or of the pyramids in Egypt, and being able to provide kids access to that sort of information is really great. And I think making sure that that is still available is important, and making sure we don't regulate away from providing kids those opportunities.
But I think this is Katharina's point, I think, continuously. I think what you're talking mostly about is how do we fund those wonderful apps? And we often fund those wonderful apps through a little bit of profiling, right? But it's different than saying you can't have Wikipedia because you want to profile children. Do you know what I mean? There's the inherent profiling of you can show meanings in the Louvre without profiling any children. It's just harder to fund it.
Well,
right?
I think that is a business model decision where there might be a company that chooses to monetize through advertising, but there might be a company that chooses not to. But I think that a lot of those companies that I saw while I was working with them at ACT, a lot of those companies that chose the avenue of not obtaining parental consent and not collecting any information, a lot of them are no longer in business.
That's right.
And whether that is because they weren't able to sell their 99-cent app, or, there's something to that effect, but also making sure that those opportunities are provided to kids, but also businesses are interested in participating in that ecosystem is also important, because the alternative is when those tools aren't available for kids, good, robust tools that provide great information to kids, kids are going to go to the tools that are made for kids over the ages, 13 and over. And that's not ideal. You don't want kids to lie about their age.
And I think, though, Paul, the one thing that I heard you say is you can do a virtual tour of the Louvre without taking information. The problem is you're mixing COPPA, which is covers an application that's directed at children under the age of 13, and general audience.
Sure.
And so what ends up happening, and I think this is the point, I completely agree with Sarah, is what happens is that if there's a diminution of the ones that are directed at kids, that speak to children in their language, that reaches them in an educationally viable way, the alternative becomes general audience. And to get to Katharina's point, then you end up with a general audience advertisement environment where the person who's putting that product in the market says, hey, look, it's general audience. I can collect on everybody and anything because unless I have actual knowledge, the actual knowledge standard kicks in. So I think what you're hearing around the table is there has to be some way to do that good delivery of good content, because the next one gets to Katharina's points about the full collection of information and advertisement in a general audience environment.
So Katharina, as one who's kind of watched the evolution of this, a few things Morgan and Sarah put on the table are, you have a lot of kind of parental, I forget the phrase you used, but get me past the consent as quickly as I can. You also have the problem that we're really talking about a threshold obligation of consent, but it's not obligations on downstream use after consent. So is there, and I guess we're talking about the law, even though I promised we would only talk about technology. Is that a fair criticism of the regime we have, that COPPA really is kind of susceptible to this one moment that we've made really, really important, that sometimes is easy to evade, and then after that, it kind of steps back into the shadows and doesn't say as much?
So you asking me?
Yeah, I'm asking you, Katharina.
Well,
yeah.
I think I mentioned before, I think the problem is we have, before, we were interested in limiting collection.
Yeah.
And so once you pass that, then you don't have rules around that. And so that's a problem. And so we need to start thinking about that. I think that's important. I might just want to also mention again the importance also of covering teens, which I think is,
Yeah.
I don't know if you wanted to come to that later.
No, let's talk about that now, right? So there's been a bill proposed, right? And Senator Markey will be here at the end of the day to match what the GDPR has done and to increase the age.
Right.
So what's the best argument for that?
So,
What's the
you know, I
argument?
feel like, you know, teenagers are now growing up in this digital market space. They're immersed in it. You know, they are being socialized. So, and they're going through a really important developmental stage where they're sort of trying to identify, you know, their own autonomy, developing their identity, and that's intersecting with their experience online. And so, you know, they're very vulnerable in this phase, and so we feel it's important that they are also being covered. We had proposed that originally in the COPPA bill. We now see, as it was mentioned, that GDPR is talked about 16. California also requires the limit up to 16. So we think it's a very important piece that the teens themselves have an opt-in right up to 16, so that they can explore the internet with all these opportunities, you know, also as sort of growing members of society, as being politically engaged, culturally engaged, so that they can do that without being harmed.
So Morgan or Sarah, either one of you, this idea that we increase the age, right? And unfortunately, we're missing Lisa's kind of, you know, participation because she would tell us about the research around the difference between 13 and 16. We're left a little bit more with kind of a step removed from that research. Maybe from the vantage point of the ACT members in particular, right, how catastrophic would a change like that be? If a lot of things are already dumbed down and geared toward a mainline audience, might it be that it may not have much of an impact to go from 13 to 16?
So I think Sarah is going to have some insights that are important to this. I learned a lot from reading Dana Boyd's work on this space, and I highly recommend all of you look at her writing about this. I don't think I'm necessarily the right voice to address some of the issues that come up in this space, especially for 13 to 16-year-old girls in particular. I think there are others who have more insight and are better capable. On the technology side of it, look, it's the reality of COPPA that it's a collection standard rather than a use standard, which creates a whole plethora of issues around that. But I think, again, I don't think I'm the best voice to talk about some of the concerns that Dana has raised, so I'd rather let someone else address that.
Sarah, I don't know if you...
Sure. Yeah, I guess I won't speak specifically to the bill, but I will, I think that Katarina's right that those ages, 13, 14, and 15-year-olds are a lot different than the 12 and under ages. And I think that it's a discussion to have, but when I think about the actual way something would be implemented, we're already having issues with getting consent from parents and figuring out a meaningful consent process for 13, 14, and 15-year-olds is sort of mind-boggling to me to figure out how are you going to verify that it's a 13-year-old? Are you going to collect more information on them because of that? What's the process there? And not to get lost in the minutia of that, but I think it's an important discussion to have because being able to get on the internet when I was a teenager provided me with a lot more access to things that I otherwise wouldn't have access to. And I was able to learn things, good and bad probably, that my parents didn't want me to learn or didn't know that I was curious about. But providing that sort of space, a safe space for kids to explore and learn how the internet works and how it will work when they're an adult, I think is an important thing to make sure that we create that sort of ability for kids to have.
And I would add one thing that's on the technical side that has nothing to do with the social aspects of it. Verifiable parental consent mechanisms in general, although they're getting better, are often derived from a point of, let's call it, high socioeconomic privilege. the community, the person who can best provide verifiable parental consent, whether it's a credit card mechanism or through some matching that goes to some other function. Yeah, it's really easy for me to say as a white college-educated person whose wife is a doctor, I've got all the touchstones so you can make sure. But one of the most important lessons I learned about this was from a woman who is a speech pathologist in Texas, who works with children who often are nonverbal, or where their devices that they need at school are such that they use them as key communications tools. Their families might be undocumented, and you can say, well, you can put it in Spanish, but it's not a simple matter of putting it in Spanish. It's a parent engagement, and those parents aren't engaged in the same way. And so anything that you do to make verifiable parental consent mechanisms more college-educated, for college-educated people, you need to think very long and hard about how there's an impact on other communities. Parents with 5 kids, one of whom has a learning difference, and that person is not undocumented, or even, they aren't, they're just a regular parent who works 2 jobs. Getting that parent to then sign that permission slip and bring it in, and then having the parent put it in, and this gets to Sarah's work on FERPA, this is a hard thing. The speech pathologist told me that the schools and others, when she was working with them independently because of working with the developers, they didn't want to have that information, right? They were like, I can't touch it, I don't want to have it. So that meant every time the kid was using this device, they had to reprogram aspects of it by hand because they couldn't keep the data for the next use and the next use and the next use. And Paul, to your point about, well, wouldn't we be better with the hoop and stick? And I say profoundly no, because a child who's able to say I love you to their mom, or I want to ask a question to their teacher that relies on a communications tool that might collect some information, I want to bias in favor of that use and not saying no just because somebody might see a sugary snack ad. So I think it's important that we, sitting here in Georgetown in a literal Ivy Tower, remember some of the other aspects of what's going on and the profound democratization of mobile technology into communities of color and, more importantly, of different learning, where a parent might only have an 8th grade education. So let's not be too fast to figure out that we know all of those aspects of it.
I mean, since I feel like that was a little bit directed at me, I will respond, right? Which is, as a person of color, the last time I checked, and a person who started out, I wasn't poor, but of more modest means than I am now.
Can we have a poor showdown? 'Cause
Yeah, you'll probably,
gotta get cracker.
No, I don't want to oversell that, but
I was so
the
poor.
point I want to make is there is another way to frame it, which is we've come up with a kind of progressive regulatory regime, quite by accident, that allows industry to prey on the children of the wealthy more easily than the children of the poor. And look, I'm not into kind of social engineering in
that
any
a
way, but
debatable
I'm not
quote?
going to lose sleep if what you claimed was true, right? If the kind of personalized advertising, the digital dossiers, the attendant downstream effects on someone's life and well-being propound more to the children of the wealthy than the poor, yeah, I can live with that. And at the same time, I think we do have to find ways to push innovation down that may or may not have to do with tracking. So I think it's a really important thing you did in your answer is there are 3 technologies we're talking about here. And I think since our job is to frame the rest of the day, let's make sure we're very clear about this. We have the technology of tracking to make an app work really well.
Yep.
We have the technology of advertising to fund innovation that we might like. And there's a blur in the middle, right? There's a blur in the middle for sure. And then the third one you put on the table is, I want to see if Sarah or Katerina have anything to add to it, is the advertising of obtaining verifiable parental consent. So the
collection
FTC recently said you can use facial recognition on a scanned identification to kind of figure out if someone is who they say they are, to lower the cost of that, to lower the burden of that, especially because people, no matter what their socioeconomic class, except at the lowest stratum, now have a high-powered supercomputer in their pocket with a really good camera, right? And so maybe that's one way to deal with the class concern. So what do we think about innovation in that third space? Is the FTC doing enough to encourage facial recognition, audio recognition, right? Maybe if I say the right thing to Alexa and Alexa's in the right mood, that counts as verifiable parental consent. And then is there a privacy concern there as well, right? The whole notion of verifiable parental consent is knowing you are who you say you are. So what do we think about that third space of innovation and technology?
I think yes, there are going to obviously be privacy concerns, because if you just have somebody taking a picture of their face and then taking a picture of their ID and emailing it over an unencrypted email address to a random person, it's probably not a great practice. But providing, I think that's one of the interesting things that the FTC can do is approve verifiable parental consent methods. I think the fact that I always like to refer to the toll-free number or the fax machine as still acceptable ways to get verifiable parental consent, because I don't know where I could find a fax machine these days. But I think innovation in that space is important, but also it's still clunky, because it's not, you don't get the immediate gratification if a child wants to use a math application that's going to help them learn their addition and subtraction, and the app needs to get verifiable parental consent, and it's 5 extra steps. Or we can use new technology. You take a Teddy Ruxpin out of a newfangled Teddy Ruxpin out of the box. But first, before you use that, the parent needs to log into a website to get it all up and running. I don't know how that's going to go over on Christmas morning.
It's bad enough to have to buy batteries. But, it's worth noting, Donna, raise your hand. There's going to be a panel at the end of the day that Donna will be at, and from that perspective of how does it work for safe harbors, and what are the things that have to be learned about. Here I am plugging later panels. Is that a good thing or a bad thing,
great.
Paul?
That's a wonderful thing.
So
We love it.
there will be some later panels and some excellent panelists here in the room who have a lot of experience with how hard is it to get a VPC up and running and actually make it marketable.
Right.
So, yeah, I mean, you maybe not surprised, but for me, I would like to see the FTC, do more about other technologies. So we're, for example, looking at VR, and sort of what are the concerns here around data collection, what are the impacts on children, all the things we don't really know about those technologies. So rather than, appreciate parental consent being important in innovation space, but there's so many other areas that I think the FTC needs to be much more proactive in and looking at, and we haven't even mentioned, going a little bit off topic, but, enforcement really should be where the energy of the FTC should be.
Right, and our third panel is all about enforcement. Okay, so I'm going to be a man of my word and bring some of the audience in. Again, I have lots of other questions, but yeah, up here, do we have a microphone? Is that how we're doing this? Yeah, it's coming up to you right now. So if you wait 1 second. And we rode the elevator together, and I know you've actually looked at some of the research that I don't have at my fingertips.
Okay, is this on?
Yeah.
Hello, I'm Kristen Walker, professor of marketing, actually, and have been researching youth privacy for a few years, probably about 6 years now. My question, I like everything that both sides sort of brought to the table, or all sides brought to the table, but my confusion is that we talk about consent, especially parental consent, as though it's privacy protection, and it's not. And when we're talking about parent expectations, I think we're talking about expectations these days that revolve around convenience. And if something's not convenient, and certainly protecting our privacy is not convenient, then that blurs the issues even more. So I wondered if you guys could talk about what you think the difference is between making consent convenient for parents, perhaps for children as well, and then the issue of that being different than protecting your privacy.
Well, you said my rant better than I did earlier, because that's my key point. And I think we all did, and I think Katarina hit that point, and Sarah did, that the odd mechanism of COPPA is this consent mechanism, and on the other side of that is not necessarily a more aware, engaged parent. And from a developer's perspective, we use the term friction. So when you add additional friction in order to protect your privacy, we see a cliff when it comes to parent involvement and how quickly parents move to moving to a different app. That's what Sarah pointed out. A lot of these guys went out of business when they added, depending on how they operated. So Yes. I actually think everyone kind of agrees with you that COPPA's consent mechanism is not the same as a meeting expectations mechanism.
And go ahead.
I just want to say, I mean, for me, the consent mechanism, as I said several times, it limits the data collection. And we have seen since COPPA that really this whole space for the under 13-year-olds has much, much less this intrusive types of advertising and marketing, and that has an impact on privacy and autonomy, on self-determination. And so in that sense, it's a success, right? And so so there is that connection between limiting the amount of data that is being circulated that can be used for advertising and the impact on privacy. So
Yeah, and I think as you're researching youth privacy, I'm going to take this opportunity to talk about FERPA a little bit.
Yeah, I was gonna ask, please go, yeah.
I think when you look at the COPPA framework as sort of a consent statute, when you look at FERPA, I'm not going to go down into, some folks that work in the FERPA space call it FERPish. And you can quickly go down the rabbit hole into FERPish. But one of the FERPA generally restricts what schools can and can't do with student data. But one of the requirements that they have, if they're sharing information with an ed tech company, the school still needs to have direct control of the data. So the school can call up whatever company, or with some companies, it's even as easy as our data, we're just going to delete it from the servers. There's a different sort of control there. And granted, COPPA has its place and FERPA has its place, but when you're looking at both of them, figuring out where the privacy protections are and what is meaningful, I think could be valuable to your research.
Other questions?
Purpose. That's new.
sounds like an animal.
We've got more, yeah, go ahead.
So this question is primarily directed at Katarina. So what I'm hearing is that there is value in having a high friction consent mechanism because it's basically, thanks. So what I'm hearing is that there's value still in having a high friction consent mechanism because it basically has this deterrent effect, and it prevents operators from collecting info from kids under 13. And so we've talked a bit about whether there is a need for evolution in what a verifiable parental consent mechanism looks like so that it does lead to more meaningful parental engagement, so that it does deliver notice in a more meaningful way. But am I correct in understanding that from a certain perspective, perhaps that evolution, we shouldn't pursue that route, and we should maintain a position where VPC is purposely hard to obtain, so companies are deterred from obtaining it, and collection is limited?
So I think if we make it easier to obtain consent, then we need to have a conversation about use, right? What kinds of uses are we comfortable with? What's good for children? What's not? What's good for different groups who are affected by this differently? What's good for society at large? So, and that there were limits, obviously, when COPPA was being drafted to what lawmakers were open to, and I think that's what we were able to obtain. But I think now, as we have this larger general conversation about privacy in general, legislation, federal legislation, we must have a conversation about uses.
I was going to apologize for answering and not being the dispassionate moderator, but I blew that 55 minutes ago. I would say I don't buy for a minute this idea that verifiable parental consent is the equivalent of climbing Everest without oxygen, right? I mean, it's a eminently solvable problem. We just don't have the incentive alignment we need to get the innovators into that, right? But so this is all tied to enforcement. This is tied to resources of agencies like the Federal Trade Commission. But if you can develop a little box that can kind of order pizza when you are sort of in the mood for it, which is essentially what we have today, you can conquer the idea that I need to know that a parent kind of in a seamless fashion is okay with what the child is trying to do in the next minute, right? It's a totally solvable problem, and it's kind of speaks to the priorities of our innovators that we're really good at ad tech, and we're really, really good at kind of data mining for lots of other purposes, but we're lousy at this thing that really isn't that hard a technical challenge, right? I mean, it's not easy. It's not easy, but it's something that's imminently solvable. If there's money to be made from it, like lots of money, we would have solved it a long time.
Yeah, I'm going to pull your programmer card on that. If it's
Yeah.
so easy,
Yeah.
then go do it, Paul. Paul, I'll sit down in the room with you.
I'd love that.
I've actually sat
If
down.
you
with-
fund me, I'll do it in a second, right?
He mentions
Yeah,
the
yeah.
magic number. He says money.
Right, so we have to internalize the externality
Yeah,
through
but-
something like law.
But the
right?
problem, Paul, is that you're competing against general audience applications.
Sure.
And so you're setting up an incentive system that's a false dichotomy.
Right.
Because, and I see some former and current FTC people in the room, unless you're going to write some really large checks to give them an enormous stick to hit around with, which, by the way, the FTC is continually under-resourced.
Yeah.
I thought it was interesting that Becca was very proud of 24 enforcements in COPPA. That's kind of embarrassing. 24? Sure. Really? Only 24? So
So I think
no,
we
it's
agree we
not-
should fund them a lot more and have a
Yeah,
lot more
but I-
enforcements.
think
I'm
it's
glad you agree with that. but-
Much harder
Yeah.
to build something. And remember, a single click box, a single window has an amazing change. Inside a lot of these companies, it's funny when we've done some of this, we've done some focus groups, and you watch how adoption of an application or adoption of a feature set will change with an addition of a single friction mechanism. So I thought your question was really on point, and it does get to this question, do we really want, in society, do we want COPPA to be a collection mechanism or a use or a use-based standard? It is, by law, a collection-based, and that creates a problem because, Paul, the only incentive that exists with a collection-based standard is get through consent as fast as possible so that you never have to deal with it again. So the idea of designing a really easy parental consent mechanism that deals with the marginalized populations, that deals with all these things, I'm sure Donna can address this and others in the room. It turns out it's really hard to do well. And yes, we throw a lot of money at it, maybe we get a little better. It's not so easy.
Yeah, and I guess one thing you keep going back to is this idea that, it's easy to hide in the kind of lax enforcement of these general audience applications. So that's another place where we could tighten the screws, of course, and call the bluff. We all in the room know that these apps are really understand who their audience is, make some money off of who their audience is. And so if we could call that enforcement bluff, all I'm trying to make, and I think you and I would agree at the end of the day, whenever someone makes a claim about like the difficulty of accomplishing something through the technology of today's world, my radar goes off immediately. It's always about incentives.
Yeah, I'll fight you about encryption, though. Encryption is math, and that's pretty hard to do.
I know, I've studied a lot of encryption. I mean, the other thing is we do authentication in lots of other places where what's at stake are money, right? And we do it well, not as well as we could do, but we do it a hell of a lot better than we do in COPPA, right? So some of that innovation ought to spill over into the COPPA space.
Yeah, I just want to also mention, maybe the app is not the only focus for the consent. So, we have platforms, Amazon gets a, one-stop shop consent, and then you're good to go with all the different apps that Amazon offers. In the same Facebook, the platforms are just going to get, it's a very relatively easy problem to solve, and then anything goes after that.
Yeah, my guess is if you had a room full of coders in here and you said, hey, these lawyers and policymakers are making this seem like this really hard problem, you'd have 50 really good ideas, but they need incentives and funding to see the light of day and to scale, right? But it's not,
incentives.
we're not
We've
really
actually
talking
done
about
that.
rocket science. The word encryption isn't this kind of insurmountable problem. We deal with
No,
it all the time.
actually, we've done that. We've actually workshopped, we've done bake-offs, we've done all the work around designing good
Yeah, but maybe you
consent
don't have the right developers in the room. Get the best developers in the room.
They're very expensive, and a lot of, and
I
some of the
understand,
companies
I
in here have
understand.
already hired
This is,
them.
but we're back to the incentives question, right?
Yeah.
You need the really expensive developers, and that's an incentives problem.
So-
No, I mean, listen, I've been writing code for 20 years. I have a computer science degree. I understand the kind of art of the possible, impossible, expensive, and not expensive when it comes to code. I don't buy for a second that we're talking about something like rocket science here, right? It's a hard problem, don't get me wrong. It's an expensive problem, don't get me wrong. But to kind of portray it to policymakers and lawmakers who don't know better as this kind of fundamentally difficult thing we're asking people to do, I don't believe that for a second. If you funded the FTC at 10x for a couple of years, my guess is you'd have really, really good verifiable parental consent at the end of those 2 years, right? Or 5 years or whatever. So, all right.
Can I just ask a follow-up?
Yeah, please.
Because I think that, I don't know if we are, but it seems to me like we might be conflating the ideas of ease and reliability of a consent mechanism. So what I'm hearing from Paul is that it might be possible to develop a super reliable and super easy consent mechanism.
Yeah.
If that's the case, then would it still be necessary to place back-end restrictions on use? Or is the idea that you only need to limit use if the method is less reliable?
That's a great point, and
on a
there's
less
two different
sliding scale?
conversations,
Yeah.
right? Yeah,
Yeah.
you can, and I'm sure we could fall all over the spectrum of that 2x2. Listen, I've got an apology. I'm an associate dean. I don't get to think about law and policy anymore, so it's all spewing out of me right now, and we were also a person down.
Yes,
Can we, if we
that
can
is a great
take,
point.
if we can take one extra minute to just have you guys play prognosticator for the next 20 years if you want, but likely are 5 years, right? What are the kind of big challenges around this entire space of, tracking, COPPA, parental consent? So let's close the panel with 3 more thoughts on this. We'll start at Morgan and we'll work our way back down. Go ahead.
I think I've said enough, so I'll let Sarah and Katerina talk.
Okay.
I think 20 years from now, it's hard to predict what technology is going to look like because it's changed so dramatically in the past 20 years. I think one of the things that we should make sure that we do is we make sure that the FTC has adequate funds to do their enforcement, and also adequate funds to make sure that they are providing guidance for the businesses and also for parents and other stakeholders so they know as new technologies come into play what the rules of the road are to make sure that they're still complying with COPPA and so that the FTC can adequately provide enforcement.
Great. Thank you.
Yeah, so just to echo that, I think that's a really important point. The FTC needs to have the resources and be proactive about the emerging technologies. So we didn't mention, for example, neuromarketing, virtual reality. All these technologies need to be sort of, before they get unleashed on children and in terms of data collection and the potential manipulation, there needs to be sort of assessed what the impact might be before. And I think the FTC has an important role to play, or any, we obviously want to have a general federal agency that really focuses on privacy exclusively.
I think we've given you a lot to chew over during the break, and I hopefully have set up the next panels, but please join me in thanking our panelists.
Great job.
Thank you all.
So we started our afternoon today by kind of talking about although I think that the conversation was broader than this, talking about the evolving tech landscape, both evolving technology and the effects on children of use of devices and online sites and services that may be subject to COPPA. And our second panel, I think that we're going to dive in a little bit into some of the key challenges and questions under COPPA. So we touched on this some in the first panel, talking about some of the, starting to apply the standards of actual knowledge, starting to think about the definition of personal information, thinking about really the legal application of COPPA and of the implementing rule. But we're going to have a little more of an in-depth conversation on this, and maybe even get into the weeds a little bit. We'll geek out on this panel of 5 lawyers on this topic. So I'm going to start by introducing our panelists here. Thanks for joining us. To my immediate left is Christine Bannon. She is the Consumer Protection Counsel at the Electronic Privacy Information Center. And in her capacity there, she's testified on behalf of EPIC before the Federal Election Commission about transparency requirements for online campaign ads. And she also runs a monthly convening of the Privacy Coalition, a group of representatives from consumer and privacy organizations who meet periodically with key Washington decision makers. She's also a certified information privacy professional. Next to her is Ariel Fox Johnson, the Senior Counsel for Policy and Privacy at Common Sense. Her work focuses on child, teen, and student privacy, closing the digital divide, and families' experiences within media and emerging technology. Her background includes both work in the nonprofit sector as well as at corporate law firms. And then we have Stacey Gray, a policy counsel at Future of Privacy Forum, and one of the co-sponsors of this event, where she focuses on issues of data collection in online and mobile platforms, ad tech, and the Internet of Things. She is an alumna of Georgetown Law School here, and also an alumna of the Institute for Public Representation Clinic here, represented by Angela Campbell in the next panel, she was in the Civil Rights Division of that clinic. And then last but not least, at the end is Emily Tabatabai. Emily is a partner and founding member of the Cyber Privacy and Data Innovation practice at Oric, where she advises clients on an array of internet commerce matters, including data privacy and data security compliance and procedure, data breach response, online and mobile privacy, student data and ed tech privacy, behavioral advertising, sales and marketing, advertising and promotions, and social media. That's quite a range of expertise. So I wanted to start by kind of asking a pretty broad question. So COPPA's an interesting law because it can help us understand how a relatively stringent privacy law applies to changing technology, something that we talked a bit about in the first panel. One of the things that it does is it creates heightened obligations for operators of online sites and services that are targeted to children or have actual knowledge that users are children. So general audience sites and services with actual knowledge that users are children. And this actual knowledge standard is one of the most discussed and highly debated, I think, issues under COPPA. So generally, and I throw this out to the whole panel, is this a good standard? Is it a good standard to have heightened obligations for things that are targeted to children or have actual knowledge that users are children? Anyone can start, but if not, then I'm going to toss it to you, Stacy, maybe to talk a little bit about what some of the observations that you've encountered in the application of the actual knowledge standard.
Sure. So thanks so much, Laura. For those of you not familiar with Future Privacy Forum, we work with a lot of different companies, both large platforms and a lot of the smaller app developers and companies that are only 2 or 3 people who are doing interesting things with data. And a lot of that is companies that are involved with the Student Privacy Pledge run by my colleague, the director of our Education Privacy Project. That's often very small companies who are dealing directly with data from children or students or students. So the actual knowledge standard, I probably shouldn't opine on whether it's good or bad, but I will say it's a useful standard to have as kind of the follow-up to services that are directed to children. When you have something that is not directed to children, but nonetheless learn that you have information from children, it seems appropriate for a federal law that's aimed at protecting children to have a heightened standard there as well. Some of the issues, however, that come up with actual knowledge that we've seen, particularly in the last 5 to 10 years, what we've seen is such a rapid growth in the Internet of Things and more connected services generally, that you have more and more data that when combined could be used to identify a child. So this primarily affects large platforms, so your Googles, your Facebooks, the companies that have so much data that if they wanted to, they could really zero in and identify who's a child and who isn't. And it affects third-party data aggregators, which I'm loosely just using to mean companies that collect data from lots and lots of different sources and use it for various purposes. Again, general audience services. And in those two contexts, we've seen more issues coming up with just the rapid rise in data collection.
And Christine, what have you noticed? So I think that one of the challenges with the actual knowledge standard is that you potentially will have entities that could be subject to COPPA interpreting the actual knowledge standard relatively narrowly, or even making efforts not to know whether users of their online sites and services are in fact children. What have you noticed, and what does Electronic Privacy Information Center think about the challenge of potential narrow interpretation of actual knowledge?
Yeah, so like any standard, I think it's how it's interpreted. It will determine how effective it is, and I think actual knowledge, the way the companies view it, is a lot different than how we or the FTC views it. Like one good example is YouTube. their second top rated channel, I think it's called like, it's like an unboxing channel for kids' toys. And the tagline is like toy reviews for kids by kids. And that is on regular YouTube, not YouTube Kids, right? And so there's, I think, just an unwillingness to really grapple with the issues that young children are using the regular platform intended for the general audiences rather than the YouTube Kids. And I think the fact that platforms are developing like beyond YouTube Kids, like the Facebook Messenger for kids under 5, shows that they have actual knowledge that children are already using their platform, and they're trying to create products that are directed towards that, right? But that doesn't solve the problem that kids are on big platform in general.
And do you think should the onus be on those platforms to take affirmative action to find out whether specific users on the platform are children, and then to apply heightened privacy standards when they know that? And this could be for you, but it's also, feel free to jump in, others, if you have an opinion on this as well.
Sure, and thanks, Laura, for having me today. I mean, at Common Sense, we're concerned that companies take advantage, especially first-party companies, can take advantage of the actual knowledge standard and just turn a blind eye to the fact that, say, they've been tracking someone going to a middle school and doing third grade math and looking at My Little Pony stuff, but say like, oh, but I didn't have their birth date. I didn't know that they were 11. And that's sort of problematic for us. I don't know if we think that they should be taking affirmative steps to dig deeply into their users. But I think Facebook said, I think this is probably in response to GDPR, that they're going to start, I think they used to maybe be advised to ignore when they came across things that were clearly children, and now, at least probably in Europe, they're going to stop doing that. Common Sense's concerns about how the actual knowledge standard is abused led us to advocate for a looser standard in California. In California, it's opt-in for sale of information.
So, and just to fill the audience in, when you say in California, what are you talking
Sure,
about there?
sorry, in the weeds already. So the California Consumer Privacy Act was passed in the summer, and it offers a number of new rights to all Californians, but one of those rights is the right to say no to the sale of your information. If you're under 16, either you or your parent has to opt in and say yes before your information can be sold. So there's a heightened protection for minors there, and if it's under 13, it's parental consent. 13, 14, 15, it's the teen has to consent. And that applies to people who have actual knowledge or are willfully disregarding the fact that they are dealing with people under 16 on their site. And, I think we would have been happy with something even newer should have known, but we got what we got. And it's still, I think, a little better than actual knowledge.
And what about you, Emily? So Emily, you counsel companies directly who are attempting to comply with the actual knowledge standard. Presumably you counsel both companies that are child-directed and those that are general audience, that have general audience sites and services. And what do you think for them? Are they making a well, I know how you. It's probably an unfair question to ask you, but is there a good faith? Is there an effort to learn whether or not there are children on the platform with a general audience site or service, or are there incentives set up basically to not know? And how do you think that you would? What are your reflections on COPPA as it relates to the actual knowledge standard?
Sure. First, I will say that nothing that I say here has anything to do with my actual clients. So these are my thoughts only. But the actual knowledge standard, I think as everyone spoke to on the panel already, the actual knowledge standard does create an incentive for companies to remain willfully ignorant. If they don't collect a birth date, or if they don't collect an easy stand-in, like a grade level in school, then they can pretty reliably skate past the actual knowledge standard unless someone actually reaches out to them to let them know that they've collected some data. So the directed to portion of the COPPA coverage is really, it's a lot more gray. It's less of the low-hanging fruit. Those cases are the ones that are always enforced. If you have actual knowledge, it's an easy enforcement action to take. The sites and services which are arguably directed to are much more challenging to bring an enforcement action against. And so there's plenty of examples, like some people have already pointed out on the panel, of cases where you just know that a site or service is directed to kids. I mean, it's obvious. There's no getting around the fact that it's obviously directed to small children. But there's a ton of general audience sites and services that fall into a pretty broad gray area where, sure, it's a general audience site and service, but then we also know anecdotally or otherwise that plenty of teens and young children are likely to be active on the platform and having their information collected. The problem is that's a lot harder to prove that enforcement case, and some companies are very, very cognizant of their responsibilities, and others are less so. One of the things our earlier panelists brought up was that companies that are very cognizant of their responsibilities here often get beat down in the marketplace by the sugary snack apps that aren't quite so responsible. So the incentives may not necessarily be there for them to reach out and affirmatively try to obtain users' ages. The one other point I would really like to raise, though, is I think where the standard, so I just criticize the standard, yet I think it's also a practical standard, and I'm not sure how we would change it. But where I think it falls down is the inability to capture the third-party sites and services that are operating through the first party. So I assume that everyone here knows what I'm talking about, but a first party would be like the website or app that the kid goes to and plays a game. The third parties are those, other technologies that are incorporated into that first-party site. So ad technologies or analytics companies or a payment portal or something like that. The actual knowledge standard for those third parties is really easy for them to avoid. Basically, they just don't ask, don't tell. And so I think that COPPA standard fails to bring under its umbrella a lot of the third-party sites and services that are ubiquitous these days.
But then in a situation like that, wouldn't you expect the primary site or service to essentially be responsible for the third-party trackers, the third-party analytics, whatever third parties it has present on its site?
Yeah, and that's currently how the regime operates. That's sort of one of the biggest challenges that I see in the way COPPA is enforced today is that those first-party sites and services aren't always the best position to be able to be responsible for their third parties. Now, I know from a policy standpoint, it makes sense to put the burden on them. They're the ones who are inviting the third parties to participate. They have to take responsibility for that. But, as we've just talked about, a lot of education apps are run by 2 and 3 people. We've seen some of the largest companies in the world, the most sophisticated, with giant legal teams, get into trouble for failing to adequately monitor what third parties are doing on their sites. So the challenge for a smaller site or service to be able to monitor that effectively is astronomical.
Great. So I want to move on and dig in a little bit deeper on this question of third parties and how to deal with that sort of shifting technological landscape where you do have many parties involved in the construction of a site or service. But before we get there, I wanted to go back to something that you said a moment ago, which was sort of about the gray area between clearly directed to kids and something that's that's very general, and ask about age gating. Because I don't think we talked much about age gating, but maybe if one of you would be willing to just explain for the audience how age gating works in when we are sort of in that gray area, and some of the reasons that that's a good thing, but some of the challenges as well.
I'm happy for you to take that one if you want.
You have to tell companies how to do it.
I do. So the FTC has said that if you have a site that's directed to a mixed audience, then you can age gate your users so that you can identify which ones are under 13 and which ones are over 13, and then apply data collection and tracking technologies and things like that only to the more adult users of your site. So in order to be an effective age gate, you have to ask for an age in a neutral manner, which does not invite falsification. So a favorite among some apps and services is, how old are you? You must be over 13 to use this site. So the person writes 13. Or they have a drop-down menu that only allows you to go back to like 2006 or whatever year we're in. Those obviously don't count as a neutral age gate because they invite falsification and don't allow a consumer to put an accurate age. But if the site, if the age gate has a drop-down menu that allows you to go back to, a year old or 100 years old, then that is currently deemed to be sufficient to identify which of your users are 13 and under or 13 and over. Lots of companies go this route, and it's a really effective way of demonstrating COPPA compliance and keeping out young children from the main data collection points on your site. I think anybody who has kids know that they figure that out real quick. So it's not that hard for a 12-year-old to fake their age. And right now, we don't have a reasonable mechanism to protect against that. And so there's a little bit of a fallacy in that. I'm taking off my, pro-business hat, but there is a little bit of a fallacy in thinking that adequately screens out kids.
Although on the other hand, I think that I've also read that it's not to the extent that children would falsify their age, it's not known to be a widespread practice. Yeah, I don't know.
That I don't know of.
All right. Okay.
My children have already tried to do it. My oldest is 9.
All right. We don't have an expert on falsification of age by children here, although we do have a few parents. But mine's only 5, and so far not into falsifying his age at all. He really wants you to know exactly how old he is. All right. So let's talk for a minute. Then let's move on to talking about having third parties help to construct sites and some of the challenges that come with that. So, COPPA is from 1998, and we're talking about the era of GeoCities. For those of you like me whose first website was a GeoCities site, we're talking about the era of GeoCities. We're talking about the era of websites and services to the extent that there were, many of which were constructed entirely just from scratch by one party. But in the modern era, sites and services generally aren't built that way, right? I mean, many people and companies, including small developers who are working on apps or new services, are not building something from scratch, from the ground up. They are using pieces or using modules that are provided by third parties that add functionality to something that they're doing. And as a result, once the completed product is constructed, there may be multiple parties involved. There might be multiple information may flow to multiple parties, all of whom have some role in construction of this site or service, but some without the direct and specific knowledge of the companies that provided those pieces, those building blocks that went into it. So broadly speaking, how has this affected COPPA? What do you guys see as some of the challenges that pop up as we apply COPPA written in the GeoCities era to today when we're living in this building block of development era?
So I'll start. I think, as Emily was saying, it's sometimes difficult for small or even really large companies to know if they're being COPPA compliant. They might think they are because, they're not collecting personal information or they don't have some sort of message board. But what they don't realize is they have a lot of social plugins, or they don't realize that those social plugins are a problem. Or like a couple years ago, Mattel got in trouble because it had embedded YouTube videos with Google Analytics. And, very large companies and not really thinking, every single step of the way, how they might not be collecting information from a child, but they're enabling someone else to collect information from a child. And that's still a problem under COPPA. And I think one reason that that's a problem under COPPA, and we're glad it is a concern of COPPA, is because COPPA has a pretty decent definition of personal information and goes sort of beyond just like my name and my social security number. And that's sort of yet another way that information collecting is captured more broadly by COPPA than by some other privacy laws.
So does this lead to a situation where there potentially are more violations taking place because neither the primary entity isn't really aware of the information that's being collected and exchanged by third parties, and third parties may not realize that they're on a child-directed site or service, or one that knows that there are children on it?
I mean, the more parties you have on a website, I guess, the more of them that can, violate COPPA. But I think, someone has to be responsible. Like, if you're going to have a site for kids, you have to, and maybe this week people have talked about what sort of negative implications this might have in terms of your business model, but you need to think about, who else you're letting get on that site. And I think it was interesting, Commissioner Slaughter was talking about, how we're spreading liability for COPPA, and one thing we haven't talked as much about with COPPA is platforms, and, they have apps that are for children. I think COPPA at this point, pretty silent about them.
And do you, so is this a problem though? Is this a problem that that will be solved over time? Will there be, so if right now you have potentially ad services or analytic services or modules that are being built into sites and services that could be collecting information that falls under the definition of personal information under COPPA without parental consent, are there alternatives that are available? If I were building a site or service and I knew that it would be child-directed, would it be possible for me to do so in a way where I would be going to providers that I know to be providing analytics or advertising modules that are COPPA compliant?
So, yes, I think is the short answer. And anything that's personalized, a plugin or an embedded feature is going to require some level of sharing of a persistent identifier. And it's important to recognize that just the collection and use of a persistent identifier does not trigger a consent requirement necessarily under COPPA if it's being used for internal business purposes, which can include making the site run, having some element of customization, doing really basic analytics, contextual advertising. Lots of things that people might not necessarily know do not trigger the consent requirements. There's a lot of things you can do. We're seeing more advertising firms these days billing themselves as a COPPA compliant service for small website publishers. I definitely think there's still a bit of a learning curve, right, particularly for smaller entities, but there's some level of growing information. And for the large platforms like Twitter, YouTube, the ones that make it very, very easy to embed something onto your website, there have been at least some efforts to build that in and build COPPA compliance in as a feature. So for example, if you're going to put a Twitter like button or Twitter share button onto your website and it's a child-directed website, you can do so in a way that is COPPA compliant by using Twitter's child-directed site flag that sends in all of the traffic, a little flag that says this is a child-directed site. YouTube, similarly, you can now embed YouTube videos as of, I don't know when they did this, 5 years ago or so. You can embed a YouTube video in a way that doesn't place cookies because it sends a flag saying child-directed site. More of that is always super, super useful.
So what you're describing then sounds like it sounds like COPPA is largely a success then in doing the very thing in a different problem, but doing the very type of thing that Paul was talking a little bit about on the last panel, right? Which is creating the legal and economic incentive for entities that potentially are developing solutions to technical problems to go ahead and develop those solutions to technical problems and provide, for example, alternatives to some of the traditional advertising options that might have existed in the past that are appropriate for a child-directed service.
So
Emily, you look like you're ready to jump in.
I would love to. Those are excellent examples, but they're basically the only ones. And I would wager to get, with like two other exceptions, and I would also wager to guess that most of these companies have innovated in this space only when forced to by regulatory pressure or pressure directly from advocacy groups. In my experience, working with a lot of companies in the edtech space or that are directed to children otherwise, it is incredibly challenging to find third-party service providers that they can implement in the types of features and services that are commonly used to support websites and apps in a way that's COPPA compliant. I mean, basic stuff like analytics and crash reporting, particularly in mobile, it's incredibly hard. First of all the third-party, not all, many, if not most, of third-party service providers are so scared of COPPA compliant violations that they include terms of service that explicitly prohibit anybody from using their services on a child-directed app. And that way, if they get in trouble or if a regulator comes calling, they can kick them off the platform and say, oh, they violated our terms. Even if the service provider doesn't explicitly prohibit it, most of them don't also tell you how you can implement it or what functionality you need to change in order for it to be COPPA compliant when it's implemented on your site. So then it's incumbent upon the first-party service to figure it out. And I work in this field, and it's pretty hard for me to figure out most times. The sales reps that the companies are talking to and they're working with these third parties often aren't giving you the right information. A lot of these services collect more than one persistent identifier. So if it's an analytics service, instead of just collecting like an app instance ID or even just a device ID, they're also collecting location, they're collecting an IP address, they may collect a MAC address or a persistent identifier and then an app-specific identifier and or an ad ID. God knows why, but they're not in the business of child-directed services, so they like broad data collection, and they don't necessarily tailor their services for a COPPA, a service a first-party service that's subject to COPPA.
So maybe
I think that's a big problem for companies.
I'm hearing one way we can make COPPA more effective or incentivize people is by having better consumer privacy protections overall, because then we don't.
Yeah, I was going to say, with talking about the regulatory pressure there being causing the development or triggering the development of the few examples that exist of the COPPA compliant third parties, I think might be what you're referencing there, Ariel, where it's like, that sounds like a good, but why is that not a good argument? I guess let me ask you that. Why is that not a good argument for more vigorous enforcement or for tighter regulatory oversights as it relates to these third parties to try to drive innovation of additional sites and service, or additional third-party plugins or third-party modules that might be COPPA compliant.
Go ahead.
Go ahead, Stacey.
Okay. So Emily's point is totally fair. Those are some of the only examples, the ones that I mentioned.
They're good ones. They're good, and we encourage that. Yeah.
Totally. But no, it's a valid point. For the larger companies that have seen pressure from advocates and from regulators, it's a totally different calculation. And Emily, you might be more aware of the ongoing litigation than I am, but my sense is that it's only in the last few years that we've seen lawsuits from state attorneys general and from the FTC, specifically including the SDK providers that are getting data.
When you say SDK,
Yeah, so generally speaking, SDK is a software development kit that third parties often provide to app publishers to make it really easy to either show an advertisement or do some kind of analytics in an app. So if I create an app, I can go to an SDK provider for analytics or advertising or whatever, and basically copy and paste the code and incorporate it into my app, which would then cause data from my app to be sent to that third-party SDK provider and used for a purpose that I've specified, and maybe other purposes as well. We've seen, so the most recent one is the New Mexico lawsuit. More legal actions being taken under COPPA against these third-party providers who are collecting data from apps that are clearly directed towards children. Now, if you go to many of them and you look at their terms of service, Emily's completely right. They simply say, don't give us information from children. We're not a child-directed service provider. The responsibility is on you, app publisher. If you are for kids, don't come to us. Don't incorporate our SDK. That's all totally fair, but if you work for the company providing the SDK, presumably, we would like to incentivize some level of basic privacy review in who is supplying the data that you take on. And how do you incentivize that? I think we'll see more of it with the ongoing lawsuits directed towards those providers to either update their terms or be more diligent in the way that they are conducting reviews, which is something short of, conducting full audits and going in and aggressively sweeping out data, but more like a basic sort of minimum standard of due diligence about who's supplying your data.
Yeah, so we first saw enforcement against a third-party operator. I believe the first one was in Moby, which was an FTC investigation or a consent decree from, 4 or 5 years ago now. And they were faulted for collecting location information from child-directed apps, even after a user of that device that had the app on it had turned off a location tracking ID and things like that. But really, they were faulted. At least my reading of that case was that they were faulted instead of the apps that embedded them, primarily because they were untruthful or misleading in the documentation that they provided to the first-party apps. The New Mexico case that was recently filed by the New Mexico Attorney General is really seeking, I think, to push the boundaries in how COPPA is applied against third-party services. And, again, talk about a little bit of low-hanging fruit. I think they picked some great examples of some services which clearly, from a variety of standpoints, could be deemed to have actual knowledge that their services were being embedded in child-directed apps. I think that's the right direction for us to go in. These companies, many of them, not all, but many of these third-party providers are not only used in almost every app in existence. It's very, very hard to build one from the ground up these days without utilizing the expertise of a whole bunch of different third-party providers for analytics and fraud detection and security services and basically anything. But these third parties are large, sophisticated. They have a substantial amount of resources, particularly compared to a lot of the small apps that use them. If we're talking about policy standpoint, they're the right group to focus on, or at least one of the right groups to focus more heavily on and encourage innovation in that space in a way that we can provide these services in a COPPA-compliant manner.
So something that's come up a couple times is I think that we've just kind of thrown out the phrase persistent identifier multiple times and talked about the fact that it falls under the definition of personal information under COPPA. And we've talked a little bit about the fact that COPPA has a relatively broad definition of personal information. So I want us to talk about this more directly and to discuss what the definition of COPPA is, and whether it's a good definition, what the challenges are. So, we have a statutory definition of personal information, and we have a heightened standard that applies when personal information, as further defined by the FTC's implementing rule, is collected. So the definition of personal information, the FTC's implementing definition of personal information changed after the 2012 rule update, and really it is pretty broad. It's pretty broad, certainly by federal standards, by federal privacy law standards. So I wonder if one of you would be willing to talk a little bit about what happened in the 2012 rule update, and why the definition of personal information is sort of interesting as federal privacy laws are concerned. Anyone who wants. I'm not 100% sure which of us worked on the 2012 rule update and is willing to talk a little bit about that definition there.
I'm happy to. I just feel like I'm talking a lot. So. Anybody?
Do you want to?
Ariel?
No. I also feel like I'm talking a lot.
Yeah, it predates me, so Emily, if you have specific experience, but it is an interesting concept. I'd be happy to talk about persistent identifiers.
All right, let's do a little background from Emily, and then we'll have reactions down the panel this way.
Yeah, so, and I'll try not to get too wonky. So the COPPA was updated in 2012, 2013 to expand the definition of personal information in recognition that back when it was passed, websites were far simpler and mobile apps didn't exist. So they expanded the definition to cover a couple of new different types of information. Let's see, photographs or images of a child with or without any other sort of information about them. So just a picture of a kid's face, even if you don't have the name. Audio recordings of the child, same thing, doesn't have to be tied to any other sort of identifier, just an audio. Expanded a personal identifier that can be used to contact the child. So instead of simply an email address of a child, it also included things like a screen name or a username, if that could be used to contact the kid or directly through the site. And then it also expanded, am I forgetting?
Geolocation.
Geolocation, thank you. It expanded it to include geolocation information, although technically speaking, I think that was covered under the original implementation of the Act, it just wasn't quite as clear. So geolocation sufficient to identify a street name as well as a city and state. And then persistent identifiers. So a persistent identifier is any identifier that can be used to track a child across websites and over time. So something that identifies a kid on that particular website, like a session cookie or even an in-app identification, if it can't be used to identify that same child through another app, that doesn't fall under the persistent ID. But persistent IDs do cover things like a device identifier, a cookie ID, any other sort of ID that's collected through, ad technology, beacons, tags, things like that. And then, interestingly, in addition to expanding that definition, the FTC also put in an exception to the parental consent requirement that allows an operator to collect a persistent identifier without parental consent if the persistent identifier is used solely for the support of the internal operations of the website, and they define that somewhat, and no other information is collected. So if you use a third-party service, for example, to collect only a persistent identifier in order to provide, web visitor analytics, they don't collect any other identification, they don't use that identifier to track people across sites and over time, they use it solely for that purpose, then that doesn't require parental consent.
And this expanded definition of personal information was in many ways a victory for the privacy advocacy community, right? So Stacy and Ariel, I know that you both work for privacy organizations that do a lot of advocacy on these types of issues. Do you view this expanded definition, and sorry, Christine, of course, you as well, and I'm going to ask you another question about this in just a moment. But do you view this? This expanded definition as a success?
Yeah, I think thinking back to 2012, 2013, I don't think, advocates got everything that we wanted, but I mean, we don't see persistent identifiers talked about in federal law. We're excited that they're included in this California law. They're in GDPR, like COPPA was pretty forward-looking, I think, and having them or just, not so backwards looking and having them in 2012, 2013. I also think the photo stuff, nowadays it makes complete sense that if you have a photo of me, even if you didn't know me, you could identify me, but in the late 90s, that would not have been the case. So I think it was, great that personal information was updated to include those things.
And Christine, what I was going to ask you is it broad enough? Are there things that you think should be added to it? Are there additional categories of information that could be used to contact a child that should fall under the definition?
Yeah, so I agree with Ariel that it's definitely was a victory for the advocacy community, and persistent identifiers is a really important expansion of the definition. I would say there are some examples of things that as technology evolves and the apps and services that kids are using change, would be important to know that they're included under the definition. So one example that comes up, is coming up more and more, is biometrics. So Epic filed an amicus in a case in Illinois state court. This is like under the Illinois biometric law, so not under COPPA because it's not covered under COPPA. So about Six Flags, they collected kids' fingerprints for their like theme park pass without their consent. So that's something that is obviously like very sensitive information used to identify a child. And I think that we would want it to be covered under COPPA. Another example is the like health trackers and like Fitbits for kids type things that are becoming more popular. The health, the sensitive information that's collected with that, another category.
Should also be subject to heightened privacy protections of some kind. And Stacy, what about adding so I think previously, when we were saying that there was something under the previous rule, I was just looking at the rule again. I think that what was in the previous version of the rule was an address, right? Was a physical address, and that was essentially like if you have a text string and it tells you what the address is of an individual, then that would constitute personal information under the prior rule. But then following the 2012 round of updates, there was this new category of just geolocation information sufficient to identify street name and name of a city or town, and that could be coordinates of some kind. And I think that you had mentioned before when we were talking a little bit about this panel and about this discussion, that geolocation information as collected maybe by third parties is presenting some issues, or you've noticed it. So I'd be curious to hear your thoughts about this and how it relates to that definition.
So I think the term persistent identifier is an excellent one because it's flexible enough to cover new forms of technology and new advancements. I struggle when I think of the additional categories that we suggest adding to think of an example that wouldn't be tied to a persistent identifier, right? So geolocation, for example, latitude and longitude is more or less useless unless it's tied to an identifier to enable you to target something to that lat long or to collect it and combine it with other lat longs over time. So most of the additional information, biometrics, everything that we consider new and different, still at the end of the day comes back to an identifier that you're using to either personalize something to that person or collect information over time. The only example that I can think of that I don't know that has been tested would be maybe some kind of digital fingerprinting that involves collection of lots of different data, none of which is by itself identifying. For example, your battery percentage on your phone. With enough of that type of data combined, you could create a proprietary ID that I guess you could argue wouldn't be a collection of a persistent identifier, but it's accomplishing the same thing, right? So I don't know that that would be super defensible. The persistent identifier term is, I think, an acknowledgement of the reality that this is how most of the app and website ecosystem works, is not through phone numbers and addresses, it's through IDFAs in the mobile ecosystem and through cookies in the web ecosystem. I mean, so the examples that we get to, I think, could go beyond persistent identifier, but I'd be happy to talk a little bit about.
I'd love to.
So one very interesting example of a push on the actual knowledge standard that we've seen in the last few years is around geolocation. So if you're talking about general audience apps and services, many of the apps that we use today that collect geolocation, that are for general audiences, that collect geolocation for one thing or another, a customized weather app, whatever it may be, I'd say most of those apps are passing the information along to third parties for various purposes. Geolocation-based mobile marketing, for example, geofenced advertisements. Sometimes we're just talking about location insights and analytics for monetization of an app, which can be very useful. Whether people expect it is sort of a different question. But if you collect enough of this from general audience apps, and we accept the premise that kids have cell phones, eventually you can, if you were to look for them, identify patterns that coincide with children. So an example of that might be transportation analytics. There are many local government bodies that are interested in collecting location-based analytics and insights reporting from third-party aggregators to do things like figure out where to build bridges or crosswalks or what have you. Very useful, very interesting. What is the legal impact when a local government is interested in figuring out how they need to structure their elementary school bus system based on how kids are getting to school? This would be a location insight report that identifies people going to elementary schools. Now, some of them might be teachers, some of them might be staff, but lots of them are children, right? What is the actual knowledge implication of that? And I think it sort of remains to be seen, but with thoughtful regulators looking at it, there's probably a line at which those third-party aggregators have an obligation to delete data once they've determined it to be children, something that's short of going in and affirmatively scrubbing out everything that you can see, going to a playground.
What about retail location analytics in a store that is highly popular with kids, like the American Girl doll store or Justice? Can you engage in retail analytics in those types of locations without having?
Right.
I guess you wouldn't have actual knowledge, but without the service being directed to or likely to be directed to kids.
I mean, as a best practice, I often advise companies that they should just geofence out elementary schools, just the same way you might geofence out hospitals or any other kind of sensitive location if you're not interested in doing things with that location. Something like an American Girl store might be a little bit harder, right?
It's a mixed audience.
Certainly a mixed audience, but then I don't know that COPPA is intended to prevent the fact that kids go places and have devices and use the internet, right? Otherwise, we'd be age gating everything. But there are a lot of very interesting edge cases. I think that's one of them for sure. Another interesting one in retail analytics is, there are lots of location service providers who collect signals that are passively emitted from cell phones to provide pedestrian traffic analysis, how long are people waiting in line, what time of day are they coming into the store. You can see this when you look at a place on Google Maps and it tells you how busy it is at different times of day. That's usually done through collecting a MAC address, which is passively emitted by any connected Wi-Fi or Bluetooth device. You can also see from the MAC address of a connected device, typically, who the manufacturer is. So you can see whether it's an iPhone, an Android, who the manufacturer is. If you can see that that manufacturer is Mattel, does that mean that it's probably a connected Barbie doll? And you should sweep that out of the data set, right? So the more we have connected devices out in the world, Fitbits and connected toys, the more we push on the actual knowledge standard, I think.
So speaking of Internet of Things, let's talk about the notice and choice approach to privacy, because this is really a notice and choice based law. The COPPA is built around the idea that that the primary thing that we need to do to protect privacy is to notify individuals, in this case parents or guardians, that information is going to be collected and used for some purpose, and then to get consent, in this case verifiable parental consent. And I think, there are some challenges associated with this framework for reasons that I think were aired a little bit on the first panel, but also certainly as we move into an Internet of Things environment. And a lot of organizations, a lot of privacy organizations have been agitating for a long time for privacy standards that really aren't notice and consent based. And Christine, I thought I would start with you here because EPIC has done a tremendous amount of advocacy around this issue. Is notice and consent the right approach to privacy under COPPA? And if not, what's the alternative?
So we think that notice and choice really isn't a privacy protective regime at all, and not just with respect to COPPA, but with respect to general privacy approach in the U.S. But obviously with COPPA, there are some different problems. But I think that the real answer to that, like lots of people that work in this space, and like we heard on the previous panel, will say that getting verifiable parental consent is really difficult, especially with IoT, because of just like the user experience. And I think our answer to that is, okay, but we need to have real limitations on like collection and use, and consent really isn't a model that's protecting parents or children.
I'm gonna, sorry, yes, I want to hear what Ariel has to say, but I was just gonna encourage folks to raise their hand if they have a question, because I'm gonna go down the line and hear a couple more thoughts on notice and consent, but then reserve the rest of the time for questions from the audience. So if you have a question, get ready to ask it, and a microphone will come your way. All right, Ariel.
Yeah, I was just going to touch on notice in the IoT space. I think it's really hard for parents. You pick something off a shelf, you buy it on Amazon, it comes to your house, you open it, your kid's super excited, you set it up, and then you get the web address or what have you, where you're supposed to, the app name, and then you see the privacy policy and what you're agreeing to, and you're not going to take that away from your child, or I'm not, taking it away from mine. So it's sort of past the point of any. It's not real consent, it's not real choice. And I thought it was interesting in your question, Laura, you were talking about notice and choice, and then you sort of moved to notice and consent.
Yes, sorry.
And is that, I mean, I think that's like sort of a fair point, because COPPA is about consent. We talk a lot about notice and choice. Usually parents don't really have a lot of choice with COPPA. It's you use the service or you don't. And, sites aren't supposed to condition a child's participation on collecting more information than is necessary. But once they've collected the information, I don't think COPPA speaks so much as to like what they can do with it. And I think it does seem like we're coming back a lot today to use restrictions being a sort of next.
Right, yeah, because there is effectively no choice to parents in many of these situations. And Stacy, you've done a ton of research and writing about connected toys, and Future Privacy Forum has done a great report on this issue.
Yeah, FPF published a report on connected toys 2 years ago now, which is incredible. That's it's been so long. Yeah, notice is really hard for things that are directed towards children that are available in retail stores for exactly the reason that Ariel pointed out. We have advised companies to put notice on the box in some form or another, but I think we're seeing, like a lot of things in the IoT space, a bit of a collective action problem in that, if nobody does it, it's hard to push any one company to put something on the box the same way that you might put batteries not included, right? I think retailers might step in here to help solve some of this problem with the sufficient incentives. Retailers are in a good position to put the sort of signage that might be helpful for smart toys in the store, akin, again, to nutrition labels. So we'll see. There could be some action on that front. Choice and consent, though, generally, there are some use restrictions under COPPA. There's a deletion ability for parents. There's the ability to access the information, to correct the information, things that don't exist in a general baseline privacy law yet. So that is super useful. Emily?
So, I think the first panel did a really nice job of pointing out some of the frictions that come into play when you need to get verifiable parental consent, frictions that are burdensome for the company, but also that just stink for the parents. They don't really want to go through this hassle, and so if it's too burdensome, they just fake it. But that becomes there are a lot more examples of that when you use services that the parents are typically the ones to set up in order for the child to access them, and this happens in the Internet of Things quite a bit. COPPA was, or one of the original intentions in COPPA was to protect children who didn't have the wherewithal or sophistication to understand what would happen to their data once they handed it over to our site. And so it was meant to give parents notice about what their kids were doing without their oversight. That's a shortened version of why it was passed, but that was one of the incentives. And nowadays, if a parent is the one who is going onto an e-commerce site, purchasing a child locator watch with a credit card, getting the watch mailed to them, opening it up, setting up the packaging, syncing it with the parent's phone. That way they can track their kid wherever they are and they're walking to and from the playground. The parent is going to be really irritated to then have to go through a verifiable parental consent mechanism in order to get the watch to actually work. I mean, the parent's setting this up. The child is not likely to be using it without the parent's direct involvement. And yet under COPPA, it's important that you go through the verifiable parental consent process before that data is collected from the device, because the device is attached to the child and it's tracking geolocation information.
And
So-
sorry.
No, I mean, I'd love to hear your thoughts on that too. It just, sometimes this notice and consent process creates some absurd consumer flows, which are not really beneficial to the consumers either.
So I'd like to hear your reaction, Ariel, and then we're going to go to questions from the audience.
And I think you make a great point about the parents' involvement, and that was one of the key drivers behind COPPA, and clearly the parent is involved in that purchase, and maybe the issue with IoT is less of a COPPA one then and more of a one about just sort of notice in general, because yeah, the parent knows they're buying this watch, but they might not know that it has a microphone in it, or they might not know all these other information collection practices of it, and that's sort of a different issue.
Great. Okay, question from the audience. Who has the microphone? Raise your hand if you have a question. Okay, Angela, Professor Campbell here.
Thank you. So my question is, I'll give you a hypothetical. Let's say that you have a
In true
website.
law professor style.
Yes, of course. And it's general audience, but there are a lot of children that use it. And you have on that website lots of different companies, third parties that are collecting information from all of the users, because you're not distinguishing, you're not using age gate. And so it seems to me from putting that information together, and especially if you have information from other sources as well, you can really know a lot about those people, consumers, the people that are on your website, including that they're children. And so at what point does that become actual knowledge? I think it has to be at some point, and but this is not the kind of case that the FTC has brought. They've been limited to the easy cases where you ask the age and then you just ignore it.
So just to clarify, are you saying at what point it becomes actual knowledge or should be deemed to be actual knowledge for the third parties who are collecting and compiling all
Or
this data?
for the first
operator?
party.
Yeah, so if the operator doesn't tend to get that information, so if it's collected by the third party is usually the one that then engages with a whole bunch of other data that they've either collected themselves or gotten from aggregators, and they feed back the first party some sort of aggregate data, like the folks who use your site generally come from Minnesota and are between the ages of 9 and 35.
Right, so if they know they have 9-year-olds, doesn't that mean they know they have children?
Yeah, what I should have said is they actually will never tell you you have 9-year-olds because they will usually
don't
say
ask.
under 18
Yeah.
in order to avoid that very thing.
And just one other follow-up. I've also seen situations where websites will say, well, we don't want anyone under 13 or an app, and if there is someone, please report them, we'll take them off right away. And I know instances where they've been reported and yet nothing has happened. I'm wondering if that seems, that's common experience. Because I think one of the problems, again, is just here that the algorithms are making decisions a lot of times, not really individual people. And so they may not even, how do you know, even if you send in your complaint the way they ask you to, that a person is actually going to see it and do something about it?
That's an area where not only greater funding for agencies like the Federal Trade Commission would be super helpful, but also better baseline privacy protection, right? If you have a broader regime of permitting data subject access requests to go through and then incentivizing the company to have someone there who actually has to respond to them, then you solve both problems.
And I
But
just wanted
shouldn't
to
it do that?
Sorry. go
I
ahead.
was just saying, shouldn't the law do that already? I mean, it says if you have actual knowledge, you have to, delete the data or.
Well, for sure, and that's clearly a violation of COPPA if someone tells you have you actually collected. The problem, though, is that, well, and I'm not saying this is a problem from a company's perspective, but COPPA doesn't permit a private right of action. And so if a regulator, regulators can only be in so many places at one time, and they only have so much funding, and those probably aren't the types of cases that they are going to go after for enforcement engagement. unless it, becomes a massive scale problem and they're just doing this at huge numbers.
Right. Yeah, which is great because the next panel is going to be on enforcement, so I'm sure that will come up. Yeah, and I just wanted to, just another reflection on the first question, the hypothetical that Angela was posing. I think that there really is this problem, right, where from the parent's perspective or from the user's perspective, the site or service is one entity. It's one thing that potentially is collecting all of this information from the individual user, and it's a lot of information that, if aggregated, could reveal all kinds of sensitive things about that person's private life. But from the developer's perspective, it's essentially a federated service, right? It's not like from the developer's perspective, they're viewing it as like, oh, we really only know this one little piece of things, and then 20 other parties know the other things. And it's very difficult to kind of to reconcile those two things. The law is essentially acting, or we think of it from a consumer perspective as acting on behalf in protection of the consumer. From the consumer's perspective, it's one site or service, but when interpreted through the lens of the site or service, it doesn't apply that way. Is there another question from the audience?
Hi. So we've talked a lot about how consent isn't necessarily so useful here. So I guess my question is, what would a use policy look like, and why do we focus so much on consent instead of on use?
Sure. So I think we focus on consent just because that's a sort of traditional framework we have in the U.S. I get to tell you what I'm doing, and you get to say yes or no. One example of a use-based framework, we can see one in the Do Not Track Kids Act of 2018, which Senator Markey, Representative Barton co-sponsored, and it updates COPPA to provide protections to teens and sort of update the under 13 stuff. But one thing it additionally does is if we're talking about under 13-year-olds, it flatly prohibits behavioral advertising. So that would be like a use-based restriction. You could also, flatly prohibit certain uses of geolocation collected information or other types of information, like, health information. Christine probably has additional ideas.
Yeah, I mean, I think, like what Ariel said, that's just sort of the model we're working with. But I think, if we were to move to like use, like there already are some use restrictions, like Stacy mentioned in COPPA. But if we were to move further away from the consent model, we need to have like a broader policy discussion about what uses we want to allow for children. And I think a flat prohibition on behavioral advertising for under 13 is definitely one of those.
Yeah, and I think that the notice and consent approach has also been really dominant historically, just because it's for political reasons, right? Because that has been the thing that is the essentially lowest hanging fruit that everyone can agree on. That at a minimum, consumers should know what information is being collected about them and how it's being used. And then, from a more, but also we're talking again about a law that was written in 1998, sort of, in the .com era. And if you imagine that you're making policy in an era where you're seeing, like now, where you're seeing tremendous innovation and expansion of digital services, then there may be a real fear and reluctance on the part of policymakers to prohibit certain types of uses before it's clear how they'll play out, like how consumers will use them, what the benefits will be, what the harms may be. And now I think, 20 years later, something that we're seeing is that there are harmful uses of consumer information that many of us may agree are harmful, and we've had sufficient time now to get to a place where there's a growing consensus that some of those practices are harmful, and we might be able to, maybe moving forward would be able to move toward use restrictions that identify some of those.
If I could just add to that, one thing we haven't talked about is COPPA does have a little bit of a sliding scale built into it currently. So it allows for a lower level of parental consent if the information is not shared with third parties. So if the site's only using it for its own purposes, like to send a kid a newsletter or to respond to them one time, or just to like allow their own site to function. Instead of getting verifiable parental consent, you can get email plus consent, which is you send the parent basically 2 notices and allow them to opt out. And I think it may be worth exploring or at least having a conversation about whether that feature can be updated to account for some of the data use practices that we feel are more benign, while still requiring verifiable parental consent for use practices that we think are more harmful or potentially more dangerous. One of the challenges that a lot of my clients struggle with daily basis ever since the 2013 update. And don't get me wrong, I think that we can all agree, and I agree as well as a parent, that behavioral advertising with children should not be going on, or at least should require consent. But one of my businesses face these challenges, which is you can't engage in any sort of free service. You have no way to monetize your site, with very limited exception. You can't engage in retargeting in order to grow your audience on other sites and services by sending ads to people who have visited your site previously. So they're really hamstrung in their ability to function like their competitors would because of the verifiable parental consent requirement for persistent identifiers. If we could update either the regulations or the way it's being enforced against third parties to incentivize them to provide COPPA compliant processes, so that businesses that are trying to comply on the right side of the COPPA law are not so severely harmed in their business practices relative to peers in the marketplace who are not necessarily compliant with COPPA, then I think that would go a long way in encouraging more companies to try to comply.
Joe, I see your hand up. So wait, hold that thought, and I'm just going to tell you guys that after Joe's question, I'm going to ask you guys to close by just offering some thoughts on how the lessons that we've learned from COPPA could influence or should influence future legislative attempts on privacy. So I'm just giving you a heads up that that's what's coming. And now Joe.
So maybe I'll be teeing that up. I guess I was just curious to know whether everybody on the panel thinks, if we're shifting to a use-based world, does the COPPA definition of precise geolocation, is that workable for companies?
Is it workable for companies? Yeah. I like it.
Sure.
Sorry, I wanted to just sort of let people tee off, but so as we discuss like how we might limit or cabin how companies use information, one conversation is what does it mean? What does precise geolocation mean? And so we're looking for definitions to pull from. Do we pull from something, say like the NAI code, which is imprecise location, or do we simply take what COPPA has already done and say expand it more broadly? That might make sense to me. I guess, there are people up here who work more directly with companies. Do you think your clients, do you think companies could accept a use-based limitation on location that uses the COPPA definition of geolocation?
There's an extent to which it almost seems like the precise geolocation definition in COPPA is a little redundant because it's always collected along with a persistent identifier. And if you have a persistent identifier, even with imprecise location, you could probably re-identify somebody over enough time, right? So maybe we're talking about, in a use restriction world, something that takes into account length of time with geolocation and not only precision, which is more of a risk-based model about re-identifying somebody based on location. And then at the other sort of hardline extreme are the ones who say that any precise geolocation data point, with or without a persistent identifier, is itself, collected over time, personal information. But then it would have to be precise, or at least precise enough, or collected over a long enough period of time to render it identifiable.
And it's relatively easy to avoid COPPA simply by truncating the precise IP address or not collecting it from a GPS. But one of the problems, I think, which led us to sort of where we are today, is that some of this data is just too easy to collect. And some of the platforms are now trying to cut back on that. So updating their platform policies to restrict apps' abilities to collect certain types of data unless it's directly related to the provision of that app services, to make sure that that notice is provided to the person downloading the app so that they can then change their settings. So I think in part, data collection, including pretty specifically geo, was just too easy to collect. And if, I can barely code my way out of a paper bag, but if you know anybody who codes things, you know that they just like to collect everything that they can. Business guys like data, and if it was offered to them, they take it, and then they figure out what to do with it. And so I think that companies got into some bad habits and over-collecting data that they didn't need. And if enforcement is stepped up, or if platforms make it more challenging to collect that data, then sure, they won't do it, or they'll work around it unless it's absolutely needed.
Yeah, I think there's a growing understanding of signals that can be used for geolocation that were not necessarily collected for that purpose. Right, so we've seen this with a couple of companies over the last few years. If you're collecting any information almost from the person's environment, the names of the Wi-Fi routers that you can see in a room, or cell towers, or proximity information from Bluetooth beacons, all of which can be used and are often collected for non-location purposes, then you run into trouble because somebody is going to analyze the network traffic and publish a report saying you're collecting geolocation information without permission. So there's a growing awareness of that, I think.
All right, so we're up on time, so I'm going to ask you guys to just offer a couple thoughts, or maybe one thought, on lessons that now that we're 20 years after COPPA being passed, what are some lessons that we can learn from how it's played out about what might make a good privacy law in the future? So Christine, I'll start with you.
Okay. Well, I'll just say that I think that COPPA is an example of successful bipartisan effort, and in our current political climate and work on the Hill, it can seem difficult that any issue can still be like that now. But I think like Senator Markey and Representative Barton's Do Not Track Kids Act is sort of a sequel to COPPA and shows that we can have success like working across party lines on children's privacy issues.
So I'd say one of the great strengths we can take from COPPA is the FTC's rulemaking authority and civil penalty authority, and able to be flexible. And one of the great weaknesses I would take from it is even when trying to be really careful with the notice and consent model, like COPPA has all these direct notices to parents and not just a privacy policy, there's still a lot of weaknesses in that approach and concerns about whether that's really effective in protecting kids.
For future efforts at legislation, I think maybe a takeaway from COPPA is that consent is a bit of a weak point, not the strongest protector of children's privacy. And maybe on a more positive note, that a collection-based restriction can really have positive effects for the market. So one of the points that I've been thinking about this whole panel and hadn't gotten to is just that there's a lot you can do without triggering verifiable parental consent. So a lot of even very sophisticated connected toys today go up to that barrier but don't cross it, and are able to provide customized, personalized, interesting, adaptive, flexible, smart services, smart toys, for example, without collecting the kind of data and doing the kind of activities that would trigger consent, and that's a good thing. So, yeah.
All right, and Emily, you get the last word.
So COPPA has been very successful in scaring companies that know about it into compliance. However, it's a really complicated statute. It's complicated to implement and to abide by, and it's really easy to accidentally cross over the line. And it presents such challenges to businesses, particularly smaller startups, that oftentimes they feel like they can roll the dice and push through in a way that makes the most sense for their business and maybe not the most compliant privacy approach, because enforcement is sparse and far between. And for every company that has a massive penalty, there's dozens and hundreds more that go under the radar. So I think to the extent that we can make compliance a little bit easier for businesses and maybe put some of the compliance pressure on the larger platform providers, on the third-party services, help spread the liability around. To the extent that we can focus on that in the future, I think we'll end up with a much broader compliant base of apps and services in the ecosystem.
All right, well, thank you very much to our wonderful panel. If I can have a round of applause for our panelists. And we're going right into a break. So I think there's a 10-minute break now, and then please return at 3:15 for our panel discussion on enforcement. Thanks again.
I'm sorry. Troy, Donna's going to start, and then we'll just go down the list. So we'll start with, go this way. So you're third.
Okay, so Donna, Toya, me, Justin?
No, Donna, Justin, you, Troy.
Oh, okay.
Okay. All right, let's get started. I want to start just by thanking Alex Gibbons, who has put this wonderful conference together. She is peerless, amazing, and we're just so happy to have her here. Today we're going to, and Alex also was smart enough to save the most important panel for last. You know, COPPA is an interesting statute. We all, we've all sort of followed COPPA for, some, if not all of its 20-year history, but without enforcement, the statute probably doesn't do much work. And so we're going to talk about enforcement. And today we have a real all-star lineup. We're going to start we're not going to just go down this list. We're going to start with Donna Fraser. Donna is the head of the Children Advertising Review Program for Safe Harbor, COPPA Safe Harbor Program. And she's going to talk at first about what Safe Harbor programs are and the kind of assistance they give in terms of enforcement of COPPA. Then we're going to talk to Justin, we're going to turn to Justin Brookman. Justin is sort of the zealot of privacy. I think he's worked at every place that does privacy work, the New York State AG's office, the Federal Trade Commission, CDT, now Consumers Union. There's nothing that Justin hasn't done in this space. Then we're going to talk to Angela Campbell. Angela, my colleague. Angela runs a clinical law project here that focuses on technology and communications. I think Angela, this is sort of uncontested, still wins the prize for filing the most complaints with the Federal Trade Commission alleging violations.
13.
COPPA 13 or 14?
I think it's 13.
Yeah, I think you should,
Well, we'll
keep it up.
get some more in soon.
And last but not least, Troya Corey is the Director of Consumer Environmental Protection of the AG's office in New Mexico. She's leading one of the more interesting enforcement actions on COPPA that I've seen, and we're delighted that she was willing to come join us today to talk about the state of litigation from a state AG's office, not from the FTC. It's a very imaginative case, and it'll be very interesting to hear about it. So, Donna, you're up first.
Okay, great, thank you. So I just want to give a brief background about safe harbors, in part because there seems to be a lot of scrutiny about either how safe harbors work or don't work, what we do, what we don't do. And there hasn't really been a lot of conversation about exactly what we do behind the scenes. So just to give you a little background, this is probably my 12th year working at a safe harbor. Prior to KRU, I ran the safe harbor program at ESRB. Both of them are nonprofits. Both of us have clean track records with regards to never having an FTC violation cited against any of the companies that we provide safe harbor to. So to that extent, I will toot my own horn and say I'm pretty good at what I do. To that end, I think it's important to understand that when a company comes to us, the first question that I have, the first conversation that I have with them is, first of all, let's talk about what it is that you're doing and what data do you want versus what do you need. Companies come to us at all stages of development. I prefer they come to us prior to actually building out their product so that we can build privacy and COPPA compliance in from the start. Doesn't always work that way. But regardless of what level or stage they come to us, we're having really in-depth conversations with them about what data you're collecting, who's collecting it for you, who are you working with, your third parties. Some companies don't have privacy policies. We help them draft and build their privacy policies. I'm an advocate of short-form privacy policies and just-in-time disclosures and things like that, particularly in a kid environment. So there's a long process. It is not a rubber stamp process. I promise you, we are not rubber stamping companies with regards to COPPA compliance. We are looking at everything that touches the data. And we walk through a product, if we're able to do so, either beginning, middle, or end stage, as a user would. We want to understand what the user experience is and make sure that what you say in your statements, your terms of use, and your privacy policy, which, by the way, we read and reconcile, we want to make sure that what is actually happening from a user standpoint is actually what's being stated in your policies. And where we find discrepancies, we talk about it. My conversation with companies is never no. My desire is always get you to yes. How do I get you to yes? Because I do believe that there are creative ways to engage children in a robust environment where you don't have to collect data. And if you choose to collect data, how do we do it responsibly? How do we do it in an effective manner? How do we do it in a way that's really only needed for that exact moment? So again, I think it's about having really good conversations with companies. A lot of companies come to the table, have no idea what they want to do or how to go about doing it. And that's what we're there for. We provide companies with developer checklists so that when they come to us on product number 1, by the time they start working on product number 2 and number 3, they have a sense of what that should look like now, what questions they need to ask internally about, well, are we kid directed or not? If we are, then we have to do this. If we're not, then we need to do that. So the cost of compliance is not often talked about as well. We've been talking all day about how COPPA works, but what we haven't talked about is the actual cost of compliance for companies. And it's not cheap. I think our programs, either the one I ran at ESRB or the one I run now, the cost of our compliance varies on a sliding scale based on revenue, but in comparison to the other 5 safe harbors, we're actually probably on the lower end, and quite frankly, we do the most work because we can remain focused. And again, as a nonprofit, we don't have to worry about our bottom line. I can put your priorities first with regards to COPPA compliance. So I'll leave it at that.
Okay. Just to be clear, under the statute, companies do get a break, sort of a break from the Federal Trade Commission if they're participating in a certified safe harbor program. The FTC actually reviews and then essentially issues a certification to safe harbor programs. And Dora's actually worked in 2 out of the 7.
Right. So, and I would say that the scrutiny that we undergo by the FTC to become a safe harbor is, it's not easy. There's a lot of paperwork involved, a lot of time involved, but we also have annual audits now that we have to respond to. Every safe harbor gets audited annually. And I have always been an advocate of oversight of the safe harbors and transparency with safe harbors. So I don't fight that. I'm an advocate of that.
Okay, Justin, you're up. You want to
Sure.
talk a little about enforcement?
Yeah. First, so I want to start by saying that, as a well-traveled advocate in this space, I've always had kind of mixed feelings about COPPA. I mean, I think the fundamental premise to limit sharing and limit targeting to kids is right, but sometimes it misses the forest for the trees. I think in some ways, like ad companies, it's like less interesting and harder to actually track kids, right? They don't actually shop. So I think most of behavioral targeting today is retargeting, so that's not really as much of an issue. They don't have persistent IDs, they don't have phone numbers necessarily, or email addresses, or they're less likely to have them, so doing some of the cross-device tracking is harder. I get the concern that if you're watching a Hatchimals video earlier, you get ads for it. I just, as a privacy advocate, I balk at the idea that this is the biggest concern. And so to the extent that I've heard some advocates saying, talking about 2019 in privacy legislation, and that maybe we can live with a federal bill that's broadly preemptive, but the focus should be on, especially on protections for kids, I want to just officially register concern with that approach. I also think it also doesn't get to some of the most important issues. So I look at a lot of kids' apps today, and there's a lot of just deeply, deeply garbage and offensive apps. And it's not because of their privacy violations. And they have privacy violations, but if I'm ranking the problems, they're not as much. So you see these apps that force kids to watch 30 seconds of videos for every 2 minutes to get 2 internet points, or that there's lots of aggressive in-app purchases, or it's confusing as what's to an ad or what it's not, or it's designed to be, addictive and keeping your eyeballs glued to the screen. I just suggest that in some ways what the FTC, this may be controversial, but what the FTC was worried about with KidVid, I think was actually probably more concerning for me than some of the privacy issues. So just saying that. On enforceability, I think it's really hard, right? Because of the breadth of exemptions that are out there, right? As long as it's for internal operations, support for internal operations, which I think could be read incredibly expansively, is really hard for the FTC to see what's going on. So, I had a lab at the FTC, and we look at these kids apps, clearly directed to kids, just spewing out information to all sorts of third parties. And there's been research on this. I imagine the Berkeley study has been referenced here today. But there's clearly a lot of sharing going on, but it's actually really hard to tell if it's for targeted advertising, absent some evidence of probably retargeting, right? Which is harder to do for kids. It's hard to tell what's going on, or if it's just for internal operations, and what actually does internal operations mean. It's actually been kind of challenging in other arenas to argue for collection limitations in the face of COPPA, which I think has a really broader exemption for collection than a lot of privacy advocates would like. So like in the do not track days, when we said, when do not track is on, you should collect information for really limited purposes and keep it for a narrow period of time. And I think COPPA is probably a lot broader than that. The CCPA, for example, came out, okay, you can collect it for limited reasons, but it has to be narrowly tailored, and you have to get rid of it afterward. And I'm not sure that COPPA goes far enough in that direction. A couple words on safe harbor. I think Dave what said is right. It kind of gives you incentives to have a safe harbor. I would argue it's not technically a safe harbor, right? It says you need to offer equal or greater protections. So logically speaking, you're just actually only adding on legal requirements that didn't exist before, if anything, which is probably not how you market the program. But I don't think it doesn't really provide a lot of incentives. Maybe, COPPA is complicated and it's called a safe harbor, so it kind of pushes people in that direction. But I think it still makes it a relatively niche product. It's interesting thinking about what alternatives would be. I know that the Obama Privacy Bill of Rights and Kerry McCain and a lot of the bills that came up last time around had more expansive safe harbors that were kind of predicated upon negotiated rulemaking. And I know the Obama bill was super complicated and arguably Byzantine about, if you meet with privacy advocates and you can get it approved in 90 days. But I think it's interesting that all the privacy bills that I've seen in the last 6 months, and that's a lot of them, don't really have that, right? That's kind of been abandoned. And maybe that's because the Obama administration pushed forward with multi-stakeholder convenings anyway, absent a law, without any real reasons for companies to agree to meaningful protections, and that went sideways. But I don't know, I'm interested in safe harbor programs. I'm interested in the value of these things. I'd be curious what folks with more experience with COPPA think would be, more aggressive ways to get folks involved in these programs. So I'll stop there.
Okay, thank you. Angela, you want to talk about your 13 petitions?
No, I'm not going to talk about that. I'm going to talk about the safe harbors. The first one I filed was actually pre-COPPA. I represented the Center for Media Education, that organization that Katerina was with. We filed a complaint against a website called KidsCom, and staff agreed that there were problems with it, and it kind of started the ball rolling towards getting to the COPPA legislation. But at that time, many of the companies and the trade associations were saying, oh, no, we don't need government regulation. We can self-regulate this. And this is a strategy that KRU and others had used many times before when the government threatened to regulate something. But in this case, it didn't work. And we got COPPA. But COPPA did provide, as David said, these incentives for companies to join safe harbors, and essentially allowed the FTC to delegate the authority to enforce to these third parties. Now, of course, here we go.
You have slides?
I have slides. I'm not going to spend too much time on this, but there's a process that a safe harbor has to apply to the FTC. They have to get public comment. They have 180 days to approve it. And then since the revision of the COPPA rules, they have to also file annual reports. And they do have the criteria that Justin mentioned. Has to be the same or greater protections. There has to be effective mandatory mechanisms to independently assess members' compliance and effective disciplinary actions for members who do not comply. Now, back in, when I was working on the COPPA back in the 90s, I got interested in whether these safe harbor programs were actually effective, and I did this whole law review article where I surveyed all of the ones that I could find that related to media, and I was generally pretty negative about their success in actually preventing abuses. However, I was much more excited about the COPPA provision because it was different than most self-regulatory provisions. It actually did provide for the FCC to have some supervisory authority, and I thought this model might work a lot better than just plain old industry self-regulation. Okay, so I decided after they started requiring these annual reports that this might be a good time to actually try to investigate whether or not they had been successful. And so I went to the FCC and I asked if I could see the annual reports, and they said, nope, sorry, those are confidential information, or they're not public. They said you can file a FOIA request, so I did. Here, by the way, here are the 7 ones that had been approved by the FTC. And this is typical of the response that I got. They wouldn't tell me like even the most basic questions like how many members did a safe harbor have? That was considered confidential. So then I tried going to look at the websites of the different safe harbors, and what I found was a real mix of information. Some of them would didn't list any of their members. Some of them listed samples or examples of their members, and there's one at least that did list them all, but the problem is you had to click on each one individually, determine which kind of certification they had, because they had 3 different certifications, and one of them only included COPPA. So.
Do you want to know why?
Sure.
So I will explain why we don't list. When I started ESRB, we did have a public listing of who our safe harbors were, and we started to have our member companies poached by competitors. And it became very difficult as one of the few nonprofits in the space to maintain our business because everyone was poaching. Because as the self-regulatory body for the video game industry, we are presumably dealing with the larger companies and the ones who make the most money, supposedly. So everyone's chasing those companies. So I pulled the list down. Because I could not compete effectively because everyone's undermining our pricing and going after our companies. And I agree that there should be a level of transparency, but I think that this is a conversation that the safe harbors need to have. Are we ever going to come to an agreement when you have 2 nonprofits and 5 for-profits to say we're not going to go after your companies? It's a competitive space.
Sure.
So that is why none of us now publish who our safe harbors are.
Oh, that's not true. I just looked
One
this
of
morning.
one does.
Okay.
One does.
Well, anyhow, what I really want to talk about, though, is that I think the concept of safe harbors is flawed. The idea behind a safe harbor is that, the member will go through this process that Donna described, and then if they pass, then they will get the seal that they are allowed to display on the website or on the app. And typically, if you click on the seal, it will take you to the Safe Harbors website, and they'll verify whether, in fact, they are a member. So the idea is that, parents who are really busy, they don't have time to read privacy policies, and they're trying to do the right thing for their child, that they're going to feel much more comfortable if they see this seal. But the problem is that the seal doesn't really mean that they're not collecting information from their children. It just means that they have a privacy policy that meets the COPPA criteria, and that it gets reviewed once a year for compliance by the Safe Harbor. So it really doesn't take away the burden on parents of reading privacy policies, and we all know that it's very hard to read privacy policies and really understand them. So I think they may give parents a false sense of security. But even if they do know what the seals mean, it's it's really confusing. There's 7 different safe harbors, and some of them have multiple seals, and they often look quite alike. And I think it would be very hard, without spending a lot of time looking at the fine print on the websites, to figure out what these different symbols actually mean. I personally have looked at a lot of websites and apps. I haven't seen a lot of seals, and sometimes I've had to look really hard to find them. Here's an example. This one actually is a KRU example. They have Hershey's.com as one of their members, and this is a website for Jolly Rancher candy. And on the website itself, I didn't see any seal for KRU at all. Now, I had to scroll all the way down to the bottom, and you can see in the bottom right-hand side, it says privacy policy. I clicked on that, and it took me to this privacy policy, which has the seal. Now, maybe if we have time later, I'd like to ask Donna what that seal means, because it says it's for general audience, I think.
Right.
So, but in any event, that's one example. The websites are generally better than the apps. When you look at apps, you go to the App Store, right? And you can look wherever you want, there's no seal on there. This is, example is from, it's a Dr. Panda game, I think Dr. Panda ice cream, and they're members of the KidSafe Safe Harbor. So again, you have to go to the privacy policy, and then you have to read the whole privacy policy. It's quite long, or at least scroll down, because the seal's at the very bottom of the privacy policy. Then I even found one. Here's another app that's targeted. It's on the Play Store. It says it's for ages 6 to 8. And it doesn't have it's a member of the ESRB Safe Harbor. This app is developed by Hasbro. And if you scroll to the bottom, again, you'll find the privacy button or privacy link. And it will take you to their privacy notice. But what's interesting about this one is that the privacy notice says we protect, we collect all kinds of information. It's actually very clear, on the whole, pretty well written in terms of what they do. But then they say, but our privacy, but our websites are not intended for children. So, and then they do say something about the apps, and they do say that they're collecting certain things, but you have to, spend a lot of time trying to, depending on the name of your app, they collect different information and so on. So the gist of it here is I think that it's very hard for anyone and parents, especially to determine if someone's complying with COPPA. And we've heard this example. Mostly the problem comes up with ththese persistent identifiers where they say they're using them for internal purposes, but you really never know. So parents, because they don't know and they are unlikely to file complaints. I would like to know how many complaints, for example, different safe harbors have received, or even if they know they can file a complaint, it's the cost of your time to file a complaint is hardly worth the benefit. So I think, and then if they don't file complaints, then of course the whole monitoring process doesn't work for these safe harbors. So I think there's a lot more that needs to be investigated here, but my research, at least so far, suggests that there are some serious drawbacks.
So Donna, I'll give you a chance to respond after we hear from Choya.
Thank you.
Well, first of all, thanks for having me. I know the Attorney General wanted to be here, but he wasn't able to fit it into his schedule. And I also want to make sure that I give credit where credit is due. As you all know, New Mexico filed a lawsuit against a host of players in this field, and no big lawsuit is a single-person task. And so I have a great team behind me. I want to thank them. In particular, I want to thank my staff attorney, Brian McMath, for his help with this case in particular. I want to talk a little bit about the state perspective for enforcement. My division is called the Consumer and Environmental Protection Division, partly because we don't believe in short titles at our office, and partly because we take an interdisciplinary approach to enforcement. And so whether it's enforcement in this space or in the pharmaceutical space or in the energy space, enforcement is something that companies have to deal with. I tell this to the charities that we regulate as well. Enforcement just is. So one of the things that we deal with when enforcing, whether it's COPPA or any other statute, is that you run across bad businesses that are just plain bad for everybody, because bad business is bad for everybody. What it does is the law sets a standard, and then you have businesses that fall below that standard. And as we've heard multiple times today, those businesses that concern themselves with being above that standard are at a competitive disadvantage to those businesses who don't bother to meet that standard or who try to subvert that standard. And so what we're doing with enforcement is making sure, one, that the playing field is level, and two, protecting, in this case, children. And Attorney General Balderas has a long history of protecting children, whether it's through criminal enforcement actions or enforcement actions like the one that we have just filed against Google, against Tiny Lab, and, as I said, a host of others. To talk a little bit about Safe Harbor, unfortunately, my life is comprised of bad actors. If it's a good actor, very, very rarely do I ever see it. And so our perspective, my perspective here today, comes at it from the point of everything that I see is discouraging. And whether again, if I said, in the energy industry, in the environment space, or whether it's in COPPA. So as far as self-regulation and safe harbors go, there's a couple concerns that, as an enforcer, we have. First, anytime it's voluntary, the incentives have to match the opposite incentive. So in this case, you have voluntary compliance, voluntary subjecting themselves to a safe harbor program. That incentive of being safe has to match or outweigh the incentive of playing fast and loose with the rules and maybe not complying with the law, which is where enforcement comes in. So in order for the incentive of safe harbor to actually attract self-regulation, the enforcement has to be strong and it has to be robust to make the penalties and the hardship for not complying more costly than complying with the law. The other thing that I think our lawsuit kind of speaks to is if you have companies who are accurately representing their product, then we're talking about a whole different ball of wax. One of the things, as we saw with the slides that Angela just put up, those websites, those apps were designed for a very specific age range. And yet, as she pointed out on their websites, they're saying they are not kid-directed. They are designed for adults. And so with many of the apps that we see in this space, they say they're designed for everybody, that they're family-friendly, that they're maybe general audience. But when you look at them, and just drawing an example from our lawsuit, Fun Kid Racing, there's really no argument that it's not directed at kids. It literally says it's in its name. So anytime that you have self-reporting and self-regulation without appropriate enforcement, I think we run into trouble. One of the other concerns that we see from a regulatory perspective and enforcement perspective is when you have a closed system that is not transparent and essentially voluntary, you run into trouble. My division, we are handling the opioid lawsuit, so the lawsuit that New Mexico has filed against opioid manufacturers and distributors. And I draw this comparison because in the opioid and pharmaceutical industry, we have seen the distributors who are supposed to self-report the very same people who they are making the biggest profit from, right? They're supposed to report suspicious orders. So if you have a pharmacy ordering millions and millions of pills for a state like New Mexico that has 2 million people in it, probably suspicious, but they have no incentive to report those because it's self-reporting, it's self-regulation. We have a similar experience here. When you have an industry that is on their honor to report to a safe harbor or to be responsible to a safe harbor program without adequate enforcement, you run into trouble. Thank you.
Okay, Donna, do you want to take a minute and respond to some?
It's going to be more than a minute. So I'm not even sure where to begin with some of the inaccuracies, but let me just start with the fact that the notion that just because we file one annual report with the FTC does not mean that that's the only time we're monitoring and looking at websites. We are doing it all the time. Companies are obligated by us to let us know before they go live with something, to submit something to us so that we can review it to make sure that it has not made any impact on their existing privacy policy or terms of use. There are a lot of things that you could look at on a screen, and it's just that, it's a screen. So I would encourage you all to actually have a real conversation with me about this. I also want to make a point about the mobile app storefronts, 2 points. One is that the information that's available at a storefront level is not controlled by us, Safe Harbors. It's not even controlled by the companies. They have limited space to make whatever disclosures they can and want to make. Whether or not they choose to, we encourage them to make whatever information they can make available about what they're doing with kids' information, but it's a marketing tool for them. So that's an issue that I think is well beyond what Safe Harbors can or cannot do. It may even be well beyond what the FTC can or cannot do. But also, let's not confuse the fact that an app rating has nothing to do with whether or not an app is collecting information about a child. When you see an app that's rated appropriate or E for everyone or appropriate from 6 to 8, that's about the content. It's not about the data collection practices. And that has been a huge, I think, point of confusion, point of contention. And it's also very confusing, I think, for parents. And consumers in general. I think the notion that seals are supposed to inform and educate parents, we need to roll that back and talk about what parents actually know about COPPA. Do they even know? And whose role is that? Maybe it's the entire ecosystem that's in this space, and it's all of us that are responsible for informing parents about COPPA. But the seals are really intended to actually notify consumers, notify regulators that you've undergone a certain level of scrutiny with regards to your data collection practices and what you're doing. Seal placement, again, especially on websites, is about a company making a decision about that space at the bottom of a website. That's a lot of real estate, and that's a lot of money that companies use and spend on that real estate. We can argue and debate back and forth with them about prominence and placement and all that sort of stuff, and I do. But at the end of the day, we do want the disclosure to be there. So is it a banner pop-up when you roll up on a website and it says, and you see the KRU seal? I don't think that's what you want. So we've got to find a happy medium there. I think it's important to note that, again, what exists now in COPPA really was based on KRU's privacy online guidelines originally, so we're not new to this space. And I think that what is looked at with regards to how safe harbors operate is very individual. It's supposed to be a level playing field. It clearly is not. So I take a little bit of umbrage to the fact that we are being compared to other safe harbors who may not do the work that we do. And so I think that everyone needs to be looked at under a microscope. Again, I'm about transparency. But the reason that you got the information you received on a FOIA request, again, is about the fact that we're dealing in a very competitive space, and it's not a level playing field anymore. And I wish that it was. It would make life easier for all of us. But the fact is that if you called me up and said to me, what companies are using a safe harbor, I'd tell you. I have no problem disclosing that information. But do I want to make it public so that other companies can, come behind me, find out what our fee schedule is, and then, poach us? I have to be able to stay in business. It is a business at the end of the day. So it's a very competitive field. We've had this conversation with the FTC. The safe harbors and the FTC have an annual meeting that usually I pull together, and we sit in a room and we talk about issues. Trying to get everyone to play by the same rules is intrinsically difficult. But what I will tell you is that I have had companies leave my program because I hold the bar too high. because I asked them to do too much work. So again, I'm going to argue with anything that says anything otherwise. Because I know that I've lost business. Being a safe harbor is like selling flood insurance in the desert. It's a hard sell. And part of that may have to do with the fact that there has been very few cases. But I also think that, the notion that companies are only joining safe harbors because of fear of a fine, there's a bigger issue here. It's a brand issue. For a company like Hasbro, to have one misstep and for that to go viral can cost them millions of dollars. So do they care about consumer trust? Absolutely. Do they care about their brand? Absolutely. So all of that is tied into this. It's not just about the money. It really is about the consequence of what happens if they lose consumers. And by the way, Hasbro has both adult content and children content. So I would encourage you to actually go look at that information as well.
Okay. Angela, do you want 1 minute to respond? Because I do want to move
Yeah,
this
I'll
discussion
just
on.
quickly, I guess, I have no doubt that there are big differences among different safe harbors, but again, when you look at it from the parents, and I suspect that the nonprofit ones do a much better job, but parents don't know that, and I don't know how they could be expected to know that when there's no transparency. And then the other point is that I think you're just wrong to say that the age ratings are irrelevant, because COPPA defines websites and apps and online services that are directed to children are the ones that have to comply with COPPA. So if they're directed to children in the content, then they should have to comply with COPPA.
You misunderstood me. What I'm saying is that the content rating, especially in the mobile storefront, when it says E for everyone, that means the content is appropriate for everybody. It doesn't mean that it's being directed to children.
But that one did. That one had a little star that said it was for 6 to 9 or
And it
something
said
like
E
that.
for everyone also.
Well, there's
Okay.
both. Yeah.
Okay, so we're going to move on. So I was in charge of trying to enforce COPPA from the FTC's perspective for 4 years. And let me tell you why I think enforcement is a problem, and then I'd like the panelists to comment on this. So first is, this is an incredibly diffuse industry. There are thousands and thousands of app developers out there. Yes, there are now some bigger entities, but it's still a very widely diffuse industry with lots of small players, undercapitalized players. Second, the FTC's enforcement tools are hammers. They are not surgical instruments. And to the extent the FTC concentrated its enforcement efforts, we wanted to go after big players. Why? Because if you take out a small, undercapitalized company, you can impose a civil penalty. They won't be able to pay it, and no one will pay attention. On the other hand, and this is, I think, one of Dora's points, we went after Playdom. Playdom was a company that engaged in, selling games to children. But Disney Company was in the process of purchasing it during our investigation. And so by the time we concluded our enforcement action, Playdom was owned by Disney. Now, we got a fairly substantial, I think, $3 million civil penalty, but we had headlines. And I spent a lot of time talking to the general counsel of Disney, who said, and I believe him, that the worst day of his career was the day that our settlement was announced and Walt Disney Company was accused of tracking children online. Now, that case, in my view, was worth 100 other cases. We did not want to simply carpet bomb this industry. What we did instead was we sent one of our able lawyers out to San Francisco, who for years, she was our emissary to the app development community. And so we hope to try to educate app developers to comply with COPPA. And I don't think we succeeded all that well. So safe harbors. I have a different view of safe harbors than I think almost anyone else on the podium here. I think they serve an important purpose, but I don't think we can count on safe harbors to do much of the work on enforcement. And here's why. The companies that join CARU or the safe harbors are willing to spend time and money to to worry about compliance. And yes, they may screw up, and yes, occasionally they may be venal. But by and large, these are companies that are at least trying to figure out what COPPA requires and are trying to comply. That streamlines FTC enforcement. It takes some, not a lot, but it takes some burden off agencies like the FTC and state AGs, like Choi's office, in terms of enforcement, to the extent that we want the safe harbors to really provide information to parents. That's a heavy lift. I'm not sure that's their job, other than the fact that this company is part of a safe harbor and is safe harbor compliant. I do think that one of the issues that we've ducked is we have this regulatory regime that was crafted before anyone could think about these things. I mean, this is 20 years old. COPPA predates Google, it predates Facebook, it predates virtually every company that we still know. And yet, we need it to adapt. And so, my concerns about COPPA enforcement is that parents don't know anything about COPPA. They are worried about their kids online, as they ought to be. We have not managed collectively to educate parents that there are these rules. And so we don't get a lot of complaints about COPPA noncompliance. I don't know whether the state AG in New Mexico does.
No, we don't get any complaints about COPPA.
Yeah, and so there are, it seems to me, all sorts of structural issues about enforcement that, I'd like the panel to respond or to offer their thoughts, and then I have some much more pointed questions for you all,
So I will say that KRU's other role as the self-regulatory body for the kids advertising industry is that we do investigations with companies who are not part of our safe harbor typically. And probably the last, I guess, probably 20 years, we've done over, probably at this point, over 220 COPPA cases, meaning that when we monitor the environment, whether it's mobile apps or websites, platforms, things like that, when we find someone in violation of COPPA, we send a letter to them. And we tell them what we found. We ask for them to, return a response to us. 90% of the companies we deal with want to learn how to become compliant. It's what they don't know what they don't know, right? And until someone points it out to them, they don't even know what they're supposed to do. So I would say that we have at least 90% of compliance with the companies who say to us, look, we're sorry, we had no idea, what do we do to fix this? And we work with them. And all of those cases are public. And it's supposed to be really a lesson for the entire environment. You can go online and look at the cases and see all the stuff that we've done. The small 10%, when they don't agree with us, when they don't want to work with us, we refer to a state AG or the FTC.
Right. Angela, you're next.
I agree with Donna, that's what they do. And the problem is they can't force someone to comply if they don't want to comply. And so in that case, when they have referred complaints to the FTC, I know of a couple of times where the FTC's taken action, but usually they don't. There are a number of closing letters where they say it was referred by Children's Advertising Review Unit. We investigated, they're not doing it anymore, so we're not going to do anything. No one knows about that. And again, my experience of filing many complaints that they just never, they don't even give us a closing letter. They just, they won't tell us what they do, and we don't know whatever happens to them. So I think part of it is that the FTC really just isn't enforcing. I agree with David that you should go after the bigger companies. That's fine, but I think because they actually, a lot of them, and contrary to someone saying earlier that they thought the big companies weren't worried about compliance, I think a lot of the big companies do have compliance problems, and I would like to see the FTC going after the big companies.
Yeah, I'll say first, yes, mobile phones are relatively new, but they're not that new. And plus, a lot of the data sharing, is actually very similar to the web, right? It's embedding third parties, it's an SDK instead of an ad library, but a lot of the core issues are kind of the same. FTC has non-hammers. I mean, the FTC has wielded non-hammers in lots of areas for a while. You don't have to seek maximum penalties. You can settle for relatively little, which is what happens in most non-COPPA cases. You can use warning letters or closing letters. You can provide more concrete guidance, right? I mean, they updated the FAQs to provide some more clarity, but again, I'm still not sure what does support for internal operations means. I think that's where where the rubber hits the road as far as what actually is allowed. I think it's actually a lot of uncertainty. But if you think that companies are wholesale violating it, I mean, I think maybe it's not fun to bring down the hammer, but at some point you can't just say, guys, come on, follow the law. Like, come on. At some point, you got to bring down the hammer, or else say that you're not going to. But I mean, I think you can't just, if you think that there are clear violations out there, I think the FTC can't just throw up his hand. Yes, you run into the risk of like a LabMD situation where you have a relatively sympathetic-ish defendant. But I mean, here you have a much more clear legal authority than you do about security and file sharing apps.
Troya?
I want to say that listening to all of this, if I was out of a job tomorrow, that would be amazing, right? If there were no more bad actors who are taking advantage of consumers and who were illegally collecting data, if there was no more data breaches so that data that's illegally collected then gets breached and is now on the dark web, all of that would be amazing. There are resource considerations. Speaking from a small office, I can tell you that certainly sometimes our resource selection is done with amazing precision. And so it's a choice of which bad actors to go after. And in response, Donna, you stated that these large companies are very concerned with one slip up or bad incidents losing those consumers. I think that is part of the price of making sure, this is why they're incentivized to be compliant. I agree with you completely on that. We have other actors who maybe are behind the scenes or maybe have other incentives playing too. And so all of that has to be considered in whether or not companies are going to be willing to subject themselves to regulation.
So let me put a finer point on this. I mean, to Justin's point about more enforcement cases, well, I mean, we'd love to be able to do that, but there are resource constraints. The Bureau of Consumer Protection, when I was there, had a maximum of 430 people, and we had lots and lots of other important priorities. And so we brought COPPA cases, but we brought data breach cases, we brought privacy cases, we brought financial services cases, we brought fraud cases. That just doesn't get you the kind, given the diffusion of actors in this space, you could spend all of the time 430 lawyers, and 300 lawyers had, just bringing COPPA cases. And I'm not sure you'd get much deterrence. The problem with bringing small cases is you don't get general deterrence. You get individual deterrence. If you bring big cases, maybe you get general deterrence. But Justin made another point which I think is important, and I'd like to ask the panel to comment on this, though I do this with some hesitation because I spent a fair amount of time working on the rule update in 2012-2013, but the person who really wrote it is sitting here. So I feel a little like Woody Allen in that movie with Marshall McLuhan sitting right over my shoulder. Phyllis Marcus is the one who actually wrote the rule. I just got to read it. So the question really is it time to do an update? I mean, there are questions that people have raised, and I think, Justin's point about, what is an internal operation, there's not a lot of clarity in the rule or in the FTC's guidance about this. And I don't know whether we need a different guidance document or whether it is yet again, I think this would be the 5th time since COPPA was passed that the FTC updated the rule, but is it time? And if there is sort of a need for greater clarity, what areas would you sort of target for agency guidance or supplemental rulemaking? So Justin, you started this.
Yeah, no,
so
I mean, like, I mean,
you get the first crack.
I've identified the area for me, which I think is the most confusing, because again, I mean, in the lab, you can see lots of sharing. And maybe the New Mexico case will shine some light as far as what's allowed and what's not. But I think I personally find it unclear. Is it time for a rulemaking? Maybe. I mean, speaking of resource constraints, that's also incredibly laborious and opens its own share of issues. I mean, the broader point, FTC needs 3 times the staff. Sure. Right. Yep. Totally. Yep. We can agree on that. But I mean, given the limited resources you have, whether you do impact litigation, again, picking and choosing cases is an incredibly important part of it. It does seem that there is under enforcement and like not enough fear of God out there. But I get it. I mean, there's only so many things you can do. You have the economy has grown 3 times since the 80s, and you have half the staff. So I think it's a fair point. At the very least, I think maybe providing some more clarity in the FAQs, like that's a lighter weight approach. Obviously, is that legally binding? Well, then folks complain about you.
Binding on the FTC.
Yeah.
It may not be binding on industry.
Yeah, I mean, and then folks complain that you're doing effective rulemaking through non-rulemaking processes. They have, yeah. So there's no perfect answer, but for me, this what exactly is allowed is the hardest question.
Okay.
So I often hear people at the FTC complain that they don't have a regular APA rulemaking authority, but they do with respect to COPPA, and I don't think that the FTC has used it very effectively or creatively. Now, the rulemaking that was done to update was very, very important, made some very important changes, was a big improvement, but it took 3 years to do, I think. 2.5? Okay. It takes a while, and you try to do a lot. And so one thing I'm just going to throw out for consideration, I don't know if this is a good idea or not, but you could have a smaller rulemaking that could address, for example, what are permissible internal purposes. You don't have to spend 2 years on that one, presumably, I hope. And then you would have some more clarity. Putting it in the guidance documents, first of all, it's done in secret. So a lot of times I'm surprised. I see that this guidance has come out, and where did that come from? Why did they say that? That doesn't seem right. There was no opportunity to comment on that. And then the guidance themselves are often very confusing. So I think the FTC should do more rulemakings, but they should probably maybe do smaller ones that address specific problems rather than trying to solve everything at once.
My suggestion, and we've talked about this with the FTC, is to do an expansion on the FAQs. And I think what would be most helpful is to engage, regardless of what's been said here today, the safe harbors in that conversation, because we are presumably the ones with our boots on the ground, with our getting our hands dirty on the day-to-day issues, and we do talk with each other about what we're seeing, what we're not seeing, and we all have conversations with the staff at the FTC, and I think that may be the most streamlined process to at least address some of the issues and expand on some of the definitions and some of the terms.
Troy?
Well, first, I think that maybe I should have volunteered to sit closer to the front of the panel so that all the good ideas aren't taken.
We'll start with you next.
But I agree with everything that's been said. I know one of the things that we've found very effective in New Mexico is having conversations with all the stakeholders. Not particularly in this case necessarily, but in our enforcement and our consumer protection role in general. A lot can be done with education. A lot can be done with education. And whether that's educating the companies, whether that's educating the consumer, whether that's educating other enforcement offices, I think that is a clear step forward that maybe doesn't even take the resources of rulemaking.
Okay, so I'm going to ask one last extremely provocative question that's going to annoy many people. And then after you all respond, we'll take questions from our colleagues here. So there is a provision of COPPA that authorizes state attorneys general to enforce the statute. There is no private right of action under COPPA. nor is there any preemption provision in COPPA other than to preempt state laws that are inconsistent with COPPA in a material way. So the question really is, in many areas where there's significant under-enforcement, and I don't hear anyone on this podium suggesting there's over-enforcement in COPPA, there are private rights of action. What would you think about having Congress simply add a codicil to the statute saying, and anybody...
Simply.
Yes,
Simply
yes,
get 'em
well,
to
it's a
add a
modest,
PRA.
this is a modest proposal in the Swiftian sense. But, I mean, one of the problems is that even if you aggregated all the resources of the FTC and the state attorneys general, there's still tons of app developers out there, and it's very hard to bring enforcement against basically, 10,000 or 100,000 app developers. So the question, and maybe this is just sort of a thought experiment, but what would an environment where there was a private right of action authorized by the statute, is that something that you would think is a good idea? And Choya, because you've always gone last, you get to go first then.
Boy, I'm kind of sorry I spoke up now. I think from the perspective of more light shining on this is better. Private rights of action would certainly shine more light on this. That's all I'm saying.
Donna?
I agree up to a certain extent. I think my issue goes back to how much knowledge are we dealing with in the consumer space that people can bring a private right of action? I mean, and is that really going to keep me more employed or unemployed, or I'm not sure.
Oh, I think this would be good for your business.
Yeah, I know. It might be too good. I'm not sure that I would go as far as supporting that. I think that there's a happy medium, and I'm not sure what it is.
Angela?
I would love to see a private right of action, but I do want to point out that at least in the current situation, we have a lot of big companies running to Congress saying, oh, we need federal legislation and preempt the California law. So I don't think there's any possibility of it happening anytime soon.
Yes, I didn't.
Yeah, I mean, first of all, I think that the state AG enforcement has been great, and I think it's good to see that in most of the privacy bills that are coming out, most of them seem to agree that letting the states do be extra cops, 51 instead of 1, is a good model, and obviously there's been a lot of good leadership from New Mexico and my former employer, the New York Attorney General. Not when I was there, I did not do awesome COPPA work, but they've done some interesting and aggressive enforcement in the past. I think so moving from 51 to 300 million enforcers. I'm open to it. I mean, we've argued for private rights of action in other laws, and I think it should be constrained and it shouldn't be expansive of the FTC authority. And then maybe so there should be some more clarification so there's not strike suits for just sharing with Flurry or. I don't know, maybe sharing with Flurry should be, but I'd like to see more certainty in the law before opening it up. But otherwise, I think given what has been a lack of enforcement, then yeah, I think it'd be more provocative to say whether there should be, whether we hold the App Store responsible or other parties in the ecosystem responsible, given the intermediary role they play. I'm not saying that they should, but that's also, if we're looking at an ecosystem that's broken, right, what are ways to fix it?
Well, I mean, so this raises an interesting question that Choya's lawsuit addresses, because one of the principal defendants, if not the principal defendant, is Google. And do you want to spend a moment explaining the theory under which Google is liable under New Mexico law?
Sure. Let me make a disclaimer because I am a lawyer. To the extent that my memory and my complaint conflict, go with the complaint because that's what I meant to say. For New Mexico, it is illegal to make a misrepresentation or a material omission in connection with the transaction of goods or services. So not only do we have third-party SDKs collecting information from child-directed apps, we have Google added to our lawsuit because Google hosted, marketed, if you will, these apps and failed to make the made the material omission of not telling consumers that their data was being collected in violation of the law.
Yeah, and the FTC has thought long and hard about going after the platforms on this. And I'm not sure that there's been a theory that the agency thinks is solid enough to go after the platforms. But we did reserve some time for questions from the audience. If there are questions, there's a question over here, there's a question over there. Your hand was up first, then you're second.
Hi, everyone. As long as we're spitballing ideas, and let me be clear, earlier I was not advocating for a private right of action. I was simply acknowledging that there wasn't one. But while we're spitballing, California has several times now has implemented a statute that provides a 30-day cure period. And it's a little weird because, when we're talking about data, once the data is out there, it can't really be clawed back. So the idea of a cure is a little strange. But the idea is kind of an interesting one in that it gives companies notice that they've screwed something up. It doesn't provide a strict liability, so you're not going to, devastate some sort of young company for not taking the right approach. And it helps inform others in the marketplace what types of practices a government agency would like to see. I mean, is there any thought or possibility of maybe moving the FTC towards something like that without having to sink all the resources into pursuing a major enforcement action every time?
I mean, that's essentially kind of what we do at KRU with our current investigative process. Companies have there's a cure period, there's a response period, there's a cure period. If they don't respond in due amount of time, then we have to make a decision as to how we're going to move forward with this case. So we are operating under that model. Whether or not that's something that makes sense, big picture, operationally, I don't know how.
I will say hard pass, hardest of passes. I find that idea that companies get to break the law until they're told not to deeply offensive, and it's actually probably one of my least favorite parts of the California privacy law that was put in there. And I think I think it would be, and I think the California Attorney General also justifiably said, are you kidding me? Like, it can't be the case that, we find like someone doing something egregious and breaking the law, and they're like, okay, we're done. We made the money. Apart from like what you say, like how do you cure a privacy violation is logically, difficult in most cases. But no, I think if someone, especially in an environment of such under enforcement, right, to provide greater incentives to companies to break the law, I think is a idea I will not be able to get behind.
We have a question over here.
She's coming with the mic.
She's coming, and I think...
Taking the scenic route.
Yeah.
So my question is for Choya. I wanted to hear from you a little bit more about your office's approach to enforcement in the COPPA space when it comes to persistent identifiers. Like Justin and others have referenced the difficulty of knowing whether persistent identifier is used for interest-based advertising, which of course does require consent, or for uses that don't require consent. And so you've got this incredibly complex regulatory regime, and then you also have, it's typically, in my understanding, difficult, if not impossible, to observe from the outside, unless there's retargeting, what the actual use of that identifier is. So in light of that complexity and the difficulty of seeing from the outside, like how your office approaches COPPA enforcement in this space when it comes to the persistent identifiers.
I think it's highly suspicious that in the observed instances where there's the collection of the multitude of persistent identifiers that we've seen, I mean, IP address, language, location data, device name, it's highly suspicious that this massive taking of data from apps that are specifically and apparently arguably, but we would say unarguably, directed at children is necessary for the permissible uses.
Other questions? No other questions? I guess everyone wants a drink. Well, join me please in thanking this wonderful panel.
Well, thank you all so much. I'm going to give a couple remarks, but I think if you guys actually stay here, we don't have that much longer before we wrap, so it's easier than moving down. First of all, I want to thank our terrific panelists, not only from this discussion, but from the panels earlier today. The conversation has been rich, spirited, dynamic, but it's also been more than just conversation. I think there have been some really helpful, useful, and valuable nuggets in there as well for actionable ideas, and I'm really grateful for that. This is a critical time to be thinking about what works and what doesn't work, what lessons we want to have learned in the field of privacy legislation. So I'm really grateful that we could spend the whole afternoon pulling these thoughts together today. I want to give a thank you again to our co-hosts for partnering with us on this event. Now, for those of you who have been following the conversation on Twitter today, there's been a little bit of discussion around a video clip. The video, the expression that was raised by some members of the audience was there'd be extreme disappointment if we didn't reference the Silicon Valley episode in which COPPA violations racked up to a tune, I actually made a note, was that it's something like $21 billion of fines to the team of Pied Piper for their COPPA violations. I'm very sorry to say that I'm not going to show that video, but I do have another video for you, and those are remarks from Senator Markey. He was originally going to be joining us in person today, but as those of you may be aware, there's an election going on. The Senate is out, and he is busy out of state right now. And so instead, he sent over a video that we're going to very briefly show.
Red Sox are also in the World Series. I suspect that may have
There were
something to do with it.
a couple competing priorities. Senator Markey is, of course, very well known to all of you. He is the original House author of COPPA. He has continued to be an engaged and meaningful privacy advocate ever since it passed, including by introducing bipartisan legislation this year. His video runs about 5 minutes, so I'm going to play it now, and then we'll wrap after that. So thank you.
Hello, and thank you for inviting me to celebrate the 20th anniversary of the Children's Online Privacy Protection Act. And I just want to give a special thanks to Alexandra Gibbons, the entire Georgetown Law Center, and the Institute for Technology, Law, and Policy for hosting today's events. And I'd also like to recognize FTC Commissioner Becca Slaughter for her remarks, and Laura Moy, Paul Ohm, and David Vladeck for moderating today's excellent panels, and of course, to the many panelists here this afternoon. We are grateful for your expertise and your commitment to our nation's children. Today, we celebrate a law that Congress passed back in the BF era, the before Facebook era, back when only birds tweeted. And it's hard to believe that it's been 2 decades since we told websites that they must collect consent from parents before collecting personal information online from children. That it has been 2 decades since we required websites to post clear privacy policies describing collection of children's information is extremely noteworthy. And that it has been 2 decades since we demanded that websites provide parents with access to their children's data. In the years since Congress passed COPPA, new technologies have become fixtures in children's lives. Yes, we can child-proof a pill bottle, but it only takes the swipe of a finger to open up a smartphone. In 1998, parents knew what their children were watching and buying. They could see which magazines were by their kids' bedsides and what ads they watched on television. But today, kids constantly have their faces in glowing devices, and parents are largely left in the dark. So it is imperative that we push the Federal Trade Commission to hold companies accountable when they violate COPPA. There is always more enforcement work to be done. But as we take note of the challenges, we must also recognize that there are opportunities. And I'm pleased that in light of the European and California privacy laws, we have a true moment to enact a comprehensive federal privacy law. And as Congress sets its sights on passing this privacy legislation, it is critical that children are at the center of that debate. That means extending protections to all children 15 and under, as well as creating an eraser button so mistakes kids and early teens make during childhood don't haunt them for the rest of their lives. So let's use this anniversary of COPPA as an opportunity to renew our commitment to kids and double down on efforts to keep the youngest amongst us safe. Children are 20% of the population, but 100% of our future. They're worth fighting for. We're in a new era. We have to adapt our laws, our regulations to protect kids in the 21st century. COPPA 20 years ago was state of the art. It dealt with the technology of that time. We need to update all of these laws and increase the age at which kids are eligible for protection. It should be 15 and under now, not 12. It's just a new era, and without these kinds of changes, without empowerment of parents, there are going to be real problems that we create in our society. So let's all band together to make sure that as we work next year to pass these new laws, that at the center of it is, in fact, a new constitution that protects children online in our country. Thank you all so much.